want to exit. So voluntary liquidation is for those companies. The presentation largely today would be essentially focused towards the involuntary liquidation, that is the outcome of the CIRP process. As most of the participants would be aware that the CIRP is a one-way track. Once you enter into it, there is a withdrawal which is permissible under section 12A. But in case there is no withdrawal or settlement, then obviously the process is going to take its normal course. The insolvency professional would be appointed either as the IRP, thereafter as the RP, is bound to take the process to its logical conclusion. Either a resolution plan is received by the COC, the resolution plan is accepted by the COC, rejected by the COC, but then either the company gets resolved or the company heads into liquidation. So the first condition which section 33 passes is essentially when no resolution plan is received within the prescribed time of 180 or 270 days in the case of a normal CIRP, or 90 or 135 in the case of a fast track CIRP, the adjudicating authority on an application by the resolution professional is going to pass an order for liquidation. The other conditions for initiating the liquidation is, in case there is a resolution plan which is approved by the committee of creditors and the NCLT, the adjudicating authority, is going to reject the resolution plan for non-compliance of requirements. So as a resolution professional, every plan that is received under this process will have to be vetted by the resolution professional, and he will have to certify that the plan is compliant in terms of the provisions of the code and the applicable regulations. If for some reason an approved plan, generally it should not happen, but in case for some reason the plan gets rejected for non-compliance of requirement, then the company would move to liquidation by an order of the adjudicating authority. Thirdly, if the committee of creditors would decide to liquidate the company before the stipulated period, that is before the period of 180 days or 270 days. So this was a clause which was inserted by way of an amendment. So it says that any time after the formation of the COC, but prior to confirmation of the resolution plan, including before preparation of an information memorandum. As some of you would be aware that earlier there were cases where the COCs did try to take companies to early liquidation. So all these attempts were blocked by the adjudicating authority, saying that this is the last chance for a corporate debtor to survive and to revive. So it is duty bound on the COC to continue the process and to see whether an amicable resolution is arrived at. However, it was later on felt that not all companies would want to go through this process, and the costs of the process itself would, in some cases, outweigh the benefits. So this clause was introduced by way of an amendment. So today, if the COC wants to liquidate the company, yes, it can do at any time of time. However, this is prior to confirmation of a resolution plan. And finally, if a resolution plan which is approved by the COC and thereafter by the NCLT, if it is contravened by the corporate debtor, so a resolution plan will also need to be implemented. Most important implementation would be in terms of the commercial offer which is there as a part of this resolution plan. So some of these commercial offers may be payment upfront, some of which would be a deferred payment plan. So if the payments are not made or any of the terms and conditions of the resolution plan are contravened by the corporate debtor at the time of its implementation, any person who is aggrieved by such contravention may apply to the Honorable NCLT for liquidation. So these are the scenarios in which a liquidation order would be passed if a resolution plan is not received. In case the NCLT rejects the resolution plan for non-compliance of the requirements, the COC at any point of time may decide to liquidate the corporate debtor. And finally, where a plan has been approved at the stage of implementation, there is some contravention, and any person who's aggrieved may apply for liquidation. As far as voluntary liquidation is concerned, this essentially is for solvent companies who have not committed any default. Of course, the procedure is known to everyone, and this is something which I would also be covering later in my presentation. So I would move on to the next slide for this. So unlike the position of a resolution professional, the liquidator is actually on a different footing. The liquidator is a quasi-judicial authority. Of course, now the stakeholders consultation committee has also been introduced. with certain powers. However, in most of the cases, wherever the liquidator may have a contrary view to the stakeholders consultation committee, he may record his reasons in writing and he can take that course of action. So, as unlike a CIRP, where the RP is dependent to a large extent on the committee of creditors, because the committee of creditors are going to take all important calls as far as the corporate debtor is concerned. But in case you are the liquidator, you have a lot of power. Of course, with power comes a lot of duties and responsibilities. As I've always been saying in some of my earlier presentations also, and more so it was quite true before the stakeholders consultation committee came into existence. The liquidator is a lonely person because everything you will have to do by yourself without any guidance, without any concurrence or affirmation from any third party. But with the stakeholders consultation committee coming in, the life of a liquidator today is fairly simple. Of course, he does remain responsible for whatever actions he has taken, and there is also protection for actions in good faith. But at the same time, for you to prove good faith, you always have the stakeholders consultation committee as a shield. So with powers, there are a lot of responsibilities which are cast also on the liquidator in terms of the distribution of funds and the sale of the assets. So most of these things I would cover later in my presentation. So the powers largely are to start with the claims process. So the job of the liquidator is to verify all the claims and to accept the claims. So once these claims are accepted, then they would be entitled to payment. So you are a claimant when you submit a claim to the liquidator, but once your claim is accepted by the liquidator, you form part of the stakeholder. You're a stakeholder who is entitled to receive a distribution under Section 53 of the code as a part of the liquidation estate. The most important decision that a liquidator needs to do is whether to carry out the business for its beneficial liquidation if he considers necessary. So one of the most important tasks for a liquidator is essentially to decide whether he wants to continue the business or he wants to close down the business. Now, there are various scenarios, various corporate debtors within various different lines of business. For example, a manufacturing company would be quite simple in terms of a decision making. An EPC company or an infrastructure company may be quite complex given the size of the company, the spread in which the business and the contract is conducted. The complexities as far as various contracts would be at their various stages in the life cycle for completion of the contract. So it's very important to understand the corporate debtor for which you are appointed as the liquidator. And one of the most important decision is because at the end of the day, the code is for maximization. So even as a liquidator, you are duty bound to ensure that there is no further loss to the corporate debtor. Your job is very simple, unlike in a CIRP, because your job is to sell. You sell either the corporate debtor, sell either the assets, but you need to take the call whether you continue the business. Everyone would agree that a business which is running is likely may not fetch more value, but it is likely to attract a lot of bidders rather than a business which is closed. So the important aspect is to ensure that the business keeps running so you attract potential bidders. And once there is an auction process, of course, it's a transparent process. It may lead to value maximization also. However, when you come to an EPC company, for example, I was handling an infrastructure company where I was appointed as the liquidator, and I was not the resolution professional for this particular company. So there were various projects which were ongoing as far as this company is concerned. Some of the projects were at 50% completion, some of them were almost at 90%, some were at 80% completion. Now these projects will have to be completed. These projects are delayed, they are at a time lag. If you understand in a contract, there are liquidated damages also. And there are bank guarantees in terms of performance obligations or advanced bank guarantees or EMDs, where the risk of invocation is quite high. So as a liquidator, you will need to look at each project and understand what is the cost to complete. So for example, the cost to complete a particular project is, for example, 10 rupees. And what is the realization that you're going to get out of it? The realization would be 7 rupees. Now the question is, do you complete this contract and incur a loss of 3 rupees for the corporate debtor? Now, along with that, there would also be a bank guarantee. And if the bank guarantee is live, say for an amount of 10 rupees itself, so what you're essentially going to recover is 7 rupees plus 10 rupees, 17 rupees, and you're going to spend an amount of 10 rupees. So as far as beneficial liquidation is concerned, you will also have to look at all the aspects. Now, this particular contract may also be a very important contract. Even if you do that loss of 3 rupees, at the same time, the what you call them, basically all these companies have PQs, pre-qualification requirements. So all these pre-qualifications is something which would attract an incoming bidder towards this company. So you'll have to look at various ways in which a liquidation can be carried out as expeditiously as possible and as beneficially as possible. So this is one of the most important powers and duties of a liquidator. The moment the company heads into liquidation, you will have to take this decision as far as beneficial liquidation is concerned. Now that the regulation says that within the first 7 days, you will have to call for a stakeholders consultation committee. Even the CIRP guidelines under regulation 39C says that you have to discuss with the committee of creditors whether you want to opt for sale of a going concern and when sale of a going concern would be conducted in terms of the assets and the liabilities that would be taken together. So the job is quite simple, but yes, you will need to give this cost benefit analysis to the stakeholders. As an insolvency professional, it's also your responsibility to document everything in writing so that whatever decisions have been taken as a liquidator or as an RP or as an IRP, you have documents to substantiate the basis on which the decisions have been taken. The decisions may eventually be right, the decisions may be wrong, but then it's a moving train. You will have to take decisions based on the information that is available, and those decisions will obviously would be good faith decisions. Apart from this, one of the most important aspects for a liquidator to consider is sale, because your job is nothing but to sell. I mean, as liquidators, we should not be confused. Our job and our aim is very clear. We will have to sell either the company or the assets, and you will have to move very swiftly from position A to position B to be able to sell the property more expeditiously. So you have the power to sell movable, immovable property either by public auction or private contract. We will come to most of this in the later part of my presentation. As any professional officer of the court, you can obtain professional assistance. You can also investigate financial affairs, but yes, before you take any professional assistance and appoint any professional, you will have to see that he is neither a relative of the liquidator nor a related party of the corporate debtor or has served as an auditor to the CD in the 5 years preceding the liquidation commencement date. Another important aspect for a liquidator to consider is investigation into the financial affairs to determine undervalued or preferential transactions. So if the resolution professional during the corporate insolvency resolution process has conducted an investigation into the financial matters of the company and would have arrived at what commonly we call as avoidance transactions, a preferential transaction, or an undervalued transaction, or an extortionate credit transaction, or a fraudulent transaction, including transactions which are defrauding creditors. So if an application has already been filed by him, you will need to evaluate as a liquidator. If you're the same person, if the RP continues as the liquidator, then obviously you will have to continue the same application. But then if the RP and the liquidator are two different professionals, it is upon the liquidator his duty bound to investigate and to determine if there are any such transactions. He may also elect, he may choose to continue the same application, but he will have to keep this record in the preliminary report, which is going to file within 75 days of the liquidation commencement date. As a liquidator, you have the power to institute and defend all suits, prosecutions, legal proceedings, civil as well as criminal. This would determine how early you are able to close the liquidation process, because more the number of cases which are opened, likely is the legal time which will be involved as far as you moving to a closure is concerned. One of the option would be, if there are too many civil, criminal cases, arbitration cases, is to try and sell the company as a going concern. Because if you are going to take these cases to a logical conclusion, it might take a long time. So there would be different types of suits. There could be a civil suit where there is a claim to be paid by the corporate debtor. In those cases, since the moratorium is now no longer available, these cases would now survive. Since these cases would now survive and revive, you will have to make suitable applications and defend your position. Mostly, if it is a claim against the company, we make those applications saying that either the proceedings may be abated and the creditor be asked or directed to file the claim with the liquidator, because no civil court will have any jurisdiction for matters under IBC is concerned. So that is one thing which can be done. In case the court does not grant those prayers, you can also ask the court to pass judicious orders, and those orders may be the basis of acceptance of these claims, and these claims of creditors may finally be included in the list of stakeholders. If you have criminal cases will continue against the management or the directors. It will also continue against the company. So in such cases, you will have to file for discharge application. Of course, with a prayer saying that you will cooperate and provide all information to the enforcement agencies as and when you are called upon to give such information. So as a liquidator, it is very important to make your position very clear in terms of all the legal matters on what exactly are you going to do. And you are duty bound to cooperate with all authorities. So that's something which you can't shy away from, saying that the company is in liquidation. So the best thing is to try and liquidate and sell the assets as fast as possible. And thereafter, you can file application for closure. Until you have an asset, some of the other creditor is going to come at knocking at your door. So the first thing is to try and sell the assets as expeditiously as possible. Of course, you will have to follow the guidelines, the process, the regulations, which are there enlisted in the liquidation regulations and the code. So as a liquidator, you have the power to consult any of the stakeholders who is entitled to a distribution of proceeds. Any such consultation is not binding on the liquidator. So that's the best part. Unlike a COC where you are accountable. So even if the COC does not pass a resolution by 66% and it fails by 2 or 3%, you've only garnered 60 or 61% of the positive votes. You can't do anything. But in such cases, as a liquidator, you have the power. You can disregard any consultation and you may always take an other view about it. Of course, you will have to maintain particulars of any such consultation. The records will have to be very clear. You have to create a note on why such decision was taken, even if the stakeholders advised you to do something else. As an RP, you also have the power to access any information from any information system for admission or for proof of claims. And as a liquidator, it's your duty to provide financial information within 7 days from the request to any creditor. Now, this is also very tricky. In one of the first liquidation assignments that I was handling, a lawyer came along with the creditor and asked for the bank statements, last 10 years financial statements, all the bills, invoices, records of the corporate debtor. So we asked him, under what regulation are you asking this financial information? I understand I have to give you information, but the information is also defined. So the information is very clearly defined. So anything you shouldn't take it for granted. Financial information is also defined under the regulations, which essentially says the audited financials and the claims, liabilities, etc. There is nothing much in terms of bank statements or invoices that you may have to give any creditor. So it's very important as a liquidator to understand what exactly are your roles and responsibilities before sharing any information with any creditor. You will also have to file various reports with the NCLT, basically preliminary report, asset memorandum report, which are to be filed only once. And periodically, you will have to file progress reports. Most of the NCLTs have now started hearing the progress reports. The Mumbai NCLT earlier never used to hear any progress reports, but I think over the last 1 year, all these progress reports are being filed through an IA. And as a liquidator, you will have to represent and explain where the status of the particular liquidation is. And finally, the most important is to distribute the proceeds as per the provisions of the code. So this is another important aspect that the liquidator will have to take into account, because the waterfall mechanism under section 53 will have to be very strictly followed because you cannot deviate from the waterfall mechanism and pay excess money to any of the creditors. We will come to the waterfall later in the presentation where I have a detailed slide on it. Now, some of the practical aspects in liquidation, I thought I will use my own experiences and also learn experiences from the fellow members. So, is to ascertain whether the business has to be closed down or continued as a going concern. This I have covered. When you get the liquidation order, it is also very important to intimate and communicate. So, you have to intimate the board of directors that they have been discharged and the workers and the employees on continuation of their services. So, if it is a factory, and there are workers and you are pretty sure that you're going to sell the company as a corporate as a going concern, it makes sense to continue the workers whomsoever are required. So if you are the RP of this particular corporate debtor and you know that the company is headed to liquidation, you can do a lot of pre-planning around this. But if you are a new professional appointed as a liquidator and you are not the erstwhile RP, so obviously you will have to do a lot of groundwork in the first 30 to 60 days to bring the assignment on track, understand various issues, understand whether you need to continue the worker or discharge them, so on and so forth. What we generally do in the cases where companies are not operational, all workers, if at all are there, they are generally discharged. We give them a letter of discharge saying that you have been discharged by virtue of the court order filing for the liquidation. And generally it is there in the order also that once this order is passed, the board is discharged and the workers' employees will be deemed to be terminated unless they are continued by the liquidator for beneficial liquidation. So some of these people whom we feel are essential, we continue them as consultants or as retainers. You will also have to intimate the ROC where the CD is based. Now, earlier when the company went into CIRP, you have to file an INC 28. When it goes into liquidation also, you will have to file an INC 28 saying that the company is in liquidation. It is also the responsibility of the liquidator to complete the books of accounts and to comply with all compliances, I would say including audit, filing of income tax returns. Now, there are different views between professionals on the responsibility of a liquidator to complete books. I may well understand where you get a corporate debtor under CIRP where the books have not been prepared for the last 2 years, 3 years, 4 years. There are many such accounts where books have not been prepared for 2 years or maybe the last 5 years or 8 years. In such cases, yes, you may not complete the audit, but wherever books have been prepared till the last financial year, it doesn't make any sense according to me. So that's something which we follow in all our assignments. We complete the books, complete the audit, file income tax return, so that if I'm going to sell this company as a going concern, at least an incoming bidder can look at the income tax losses, which are assessed by the income tax department. And there is some value that they can derive out of that. So once the company enters into liquidation, what you need to open is a new bank account. The regulations are very clear saying that all the liquidation proceeds will be into a new bank account by the company, followed by the words in liquidation. The regulation does not talk about closure of the old bank account. So this is up to you, but generally as a practice, we close all the old bank accounts. Even we've seen that many of the banks who are opening liquidation accounts are not giving you online banking access, or they are not giving you online transactions, at least to pay statutory dues, etc. So if you have a previous current account which is there through which online payments are being made, so it is better that you continue that account only for the limited purposes of paying statutory dues. So that's what I have done in a couple of my assignments where we had this challenge where there were no checkbooks, or even if checkbooks were there, it was very difficult to give instructions. So the bank was also very comfortable in getting instructions physically so that they also know where the payments are made rather than a check coming for clearing in the normal course of business. Suspension of trading in securities. So what we've also seen, of course, there is no guideline to this, but yes, right. I think SEBI has come up with a circular also. So suspension in trading in equity shares generally happens. So when the company enters into the liquidation phase, as a liquidator, you will intimate the stock exchanges that the company has entered into the liquidation process. In fact, in one of my case, I had not requested for suspension of the trading because we were not sure whether we can do that. But the stock exchanges and the SEBI, they themselves suspended the trading and the equity shares. And thereafter, delisting starts, which is a process which takes time, but there is no intervention as a liquidator that you have to do for delisting of the corporate debtor. However, if you want to sell the company as a going concern and if you feel the listing status would be beneficial, probably you can engage with the stock exchanges and SEBI and make a very specific request to allow the company, since you're planning to sell the company as a going concern. So if you are planning to do something, you will have to plan this even at the CIRP stage where an application for liquidation is filed. You may call for a COC meeting and minute it saying that the COC recommends to sell the company as a going concern, and suitable prayers can be made even to the NCLT in the application itself or to the stock exchanges and SEBI saying that the trading may not be suspended, of course, within their guide, if the guidelines permit. Intimation to various statutory and government authorities are something which is a part of our job now, that is also being made incidental to the responsibilities of an IP. Any questions that I may take? Let me see if there are any questions.
So I think the question that we've been grappling with in the past few days is the impact of the new amendments which bring in the Section 230 and what it does to the role of the SEC. How does that confusion get handled? I'm not sure whether you handle it practically, but what is your view?
The compromise and settlement under Section 230. That's what you're talking about? That's
right. That's right.
Yeah. So basically now the CIRP guidelines, I think the regulation is 39BA, or that talks about whether the COC wants to explore a compromise or a settlement. In case you get as a liquidator a compromise or a settlement proposal, the first thing that you will need to do is to complete all the processes which are prescribed under Section 230 of the Act. Now, during this period, what we understand also is the company will continue as a going concern in the normal course of business. And as a liquidator, you may not be able to do much in terms of sale of assets until this process gets concluded. And as you rightly pointed out, the timeline of 90 days is a challenge. But as a liquidator, what you can only do is try and push it, try and expedite it, and on good faith basis, you'll have to take all the actions. I have not personally handled any 230 case. I hope I've answered your question, sir.
Yeah, so I think I was just seeking your opinion because this was a matter of discussion over the past few days. The only conclusion which I think was taken yesterday was that it has certainly made the whole liquidation process.
Yeah, so I mean, the regulation also says that if a compromise and settlement proposal is received, the first priority would be towards compromise and settlement. Then only you can start sale of the assets. So if you've got that proposal, you have no choice but to continue. Any other questions? So there is a question which is there on voluntary liquidation. So sir, with your permission, I will take this question towards the end. But largely, I mean, all compliances will have to be done, sir. I'll take this question when I come to the voluntary liquidation. Any other questions, or I will go ahead? Let's make it a bit interactive so that, I mean, I also have 3 hours. I can speak for 3 hours. That's not an issue. I have enough material. But then if I have some questions, I think that will also benefit all the fellow participants. So the second important thing that a liquidator will have to look at is whether you want to conduct a valuation or not. Now, what the regulation says is where the valuation has been done during the CIRP period, the liquidator may continue the same valuation and you can consider the average of the estimates under those regulations. So that's one thing that you can do. The second thing which you can do is, in case the valuation has not been done during the CIRP, you will have to appoint 2 registered valuers to ascertain the estimated realizable value of the assets under clauses A to F. So A to F of regulation 32 talks about sale of the asset on a standalone basis, slump sale, asset in parcel, asset collectively, sale of the business, and the sale of the corporate debtor. So you will have to decide as a liquidator on day 1 or whenever you become the liquidator, how are you going to sell the asset? And accordingly, you will have to ask the valuers to ascertain the value of that assets in accordance to those guidelines. Now, if the valuation has been done during the CIRP period, there will have to be certain adjustments that you will have to make, because you wouldn't have sold land, encumbered plant and machinery during the CIRP process. But what would have really got out is the inventory which would be there in the normal course of business. So these are the adjustments. You can't just blindly copy the valuation report as on the insolvency commencement date and say that I'm going to consider this as the value. So if your inventory has undergone a change, both in terms of either the quality of the asset has deteriorated or anything of that sort, you will have to do those assessment again. If debtors have undergone a change, you may have to again do a valuation. So can you do a restricted valuation only for a certain class of assets? In my view, yes, because your job is also to save the money. So it's not necessary that you do all the valuations together. Most of the professionals that we speak to some of the time say that it is better to do a valuation again. But I would differ to some extent over here, saying that if you are the IRP who's continued as the liquidator, you are in the best position to ascertain and to determine whether the assets have deteriorated or not. Over the last 9 months, 12 months, 15 months, whatever time you've been there, you would know what are the value of the assets and whether the valuation reports which have been submitted by the valuers would reflect a proper value as far as these assets are concerned. But yes, there would be certain adjustments that would be needed to certain class of assets. Now, in what cases would you take a decision to have a fresh valuation, even if the valuation was done during CIRP? You can discuss this with the stakeholders consultation committee. There are some cases which takes 2 years, 3 years for getting onto the process of liquidation for whatever litigation or whatever other aspects might have happened. So you can speak with the SEC, and within the first 7 days, you can take this decision of conducting a fresh valuation. Now, most of the cases which I have handled, I have done a fresh valuation because of the COVID, there was an impact, of course, on the asset. And in one of the cases which started prior to COVID, just a couple of months before COVID, and the entire CRP process ended into liquidation. Of course, the asset was good. We did two valuations at that point of time. One of the valuations which I had got for the fair value and liquidation, fair value was 65, the liquidation value was 48. We again revalued the assets because we thought those assets have not been valued properly. Now, during the liquidation process period, I got a valuation of around 68 crores, which was the average valuation. And in discussion with the stakeholders, we put up the auction for 72 crores. And this asset got sold at 121 crores. So it's very important. So you will also think that this asset was there with me for a long time. Why didn't I see 121 crores coming? But various professionals would see the valuation from a different prism. So it's always important as a RP or a liquidator to always engage with the valuers to understand the methodology and what they have done in terms of groundwork to arrive at that particular valuation. Of course, they are subject matter experts. You cannot interfere in their judgment. But of course, you can have a discussion in terms of the rationale and the methodology which they have adopted. In most of the cases that we've seen, I mean, there is a lot of back and forth that you'll have to discuss with the valuers, because at some point of time, they'll say, I've not seen this, where as an RP or a liquidator, you've actually seen that. So it's better to look at the valuation and determine during the liquidation whether you want to initiate a fresh valuation or you don't want to initiate a fresh valuation and continue the same valuation. So different professionals would take a different view as far as this is concerned. Now, as far as legal cases is concerned, I have already shared my experience. I have already shared my views on what do we do as far as legal cases are concerned, because unless you handle legal cases appropriately, your liquidation is going to go on for a long period of time. And just to give you an example, in one of my cases, I had a property which was under a civil dispute, and the dispute was in terms of the sale consideration of the property. So we had taken a legal opinion from our advisors, and they said you can't deal with this property until and unless you get this settled at the civil court, because this is a matter of sale consideration. I think the legal term which was used was lis pendens. So they said you can't deal with this property without the permission of the court. Now the question is, do you go to civil court, you go to NCLT, but since there were many other assets and this assets was not of a material value, we continued this litigation, but unfortunately because of COVID, it took a lot of time. So addressing legal cases is one of the most important job either as an IRP RP. So as an IRP RP, it's quite simple because there is a moratorium, but under liquidation, the moratorium goes off and a barrage of cases are going to come against you. Most of these cases you will only be able to resolve because many of these cases would be civil cases for payment demanded from the company. So all these cases would be very simple. The claimants are going to file a claim wherever they have filed a claim, make a submission to the NCLT saying that they have filed a claim, and now the jurisdiction, make a submission to the court saying that the jurisdiction is now NCLT, and ask for appropriate orders. As far as criminal proceedings are concerned, now there would be two aspects to this: whether the assets are attached by any of the enforcement agencies. So you will have protection under Section 32A. But what you can also do in terms of assets which are attached under the section, attached by any of the enforcement agencies. Now, what we understand of Section 32A is during the CIRP period, if I have to file an application, I will have to file it at the PMLA. There is an unclear judgment, so I have to go to the PMLA court and file an application. However, if there is a resolution plan which is approved, at that point of time, you will get protection under Section 32A, or a liquidation order is passed, you will get protection under Section 32A. So when you're filing for liquidation of this corporate debtor, it is always better to file two applications. One is for liquidation, second is for detachment and protection under Section 32A, so that you don't waste time after the liquidation process gets initiated. You can make the enforcement agencies as a party and you can file those applications so that when the liquidation order is passed, on the same date, they will also pass, they will tag the applications and they will pass also this order for removal of attachment. So this is something which can be done. Secondly, in many of the criminal cases, you will be faced with summons. So I unfortunately handle a lot of cases where there are a lot of enforcement agencies which are involved. So periodic summons will come and you will have to have your presence felt. You will have to depute appropriate legal counsels to handle the matter. So what we've done in many of our cases where criminal investigation are underway, and these would take a lot of time as everyone would understand. So we have filed for discharge of the liquidator and the corporate debtor in these cases because I have nothing to do. What best I can do is anytime the enforcement agencies or the court would want anything from me, I will cooperate and submit whatever best I can do. So we filed for discharge, and fortunately in one of the cases, in one of the coal camps cases, we got a discharge almost a couple of weeks back by the CBI court in Delhi. So that was also carried by the Economic Times 3-4 days back. So you can file for discharge of criminal cases, but if the assets are attached, it is better to take action when the liquidation application is filed rather than commencement of liquidation and then you filing, because everyone knows that the court processes, judicial process does take some time. Any questions or do I move ahead? I will just see. Okay. No questions, fine. Now, as far as the process is concerned, the journey in the liquidation, the entire process overview, right from initiation of liquidation till the dissolution of the corporate debtor. So there are various stages in which the process is distributed. First is the claim verification and list of stakeholders. You will have to invite claims within 5 days of the liquidation commencement date, and you have to give stakeholders 30 days from the liquidation commencement date to file their claims. So once claims are received, claims will have to be adjudicated, and the acceptance or rejection of the claim will have to be duly communicated. So it's very important for professionals to understand that if you are rejecting any claim or you're part admitting any claim, it is always better to give valid reasons as if you are making submissions in a court of law. So it is always better to give elaborate reasons why you are rejecting a particular claim, so that the counterparty also knows if there are certain documents to be given. Of course, before rejecting the claim, you can ask for documents. But even after those documents, if you've asked for the list of documents, they have not provided the documents for verifying or substantiating their claim, You can, of course, reject the claim or partly admit the claim. However, it is always important to give reasons. The second is the formation of a stakeholders consultation committee, which has to be done within 60 days from the liquidation commencement date. Of course, we will come later in the slide in terms of the constitution, the composition, and what are the roles and responsibilities of each stakeholder who's there in the stakeholders consultation committee. Uh, Preparation of a liquidation estate. The liquidator is duty bound to prepare a liquidation estate. So these are all those assets which you can sell. If you would have read the disciplinary orders, and nowadays a lot of disciplinary orders are coming out from the IBBI, and most of them we can see some gaps or the other. I'm not saying all these. Everyone would run the entire process because this is a live process, it's not a post-mortem, so you will have to take calls based on the information that is available. And yes, sometimes you may go wrong, may not be intentional also, but a liquidation estate is very important because you will have to put this as a part of your asset memorandum, and all the assets which are to be sold by the liquidator will have to be mentioned as a part of the liquidation estate. Now, what forms part of the liquidation estate? It's only those assets which are relinquished by the secured creditors. So in case the secured creditors have not relinquished any of their assets, these assets are not going to form part of the liquidation estate. Reporting by the liquidator. As a liquidator, you will have to do periodic reporting. So I have a detailed slide later in my presentation on this. Manner and mode of sale of asset. So manner of sale is essentially the ways in which you can sell the company. Either you can sell the company asset on a standalone basis, or you can also sell the corporate debtor as a going concern. And the mode of sale is either you can sell by a public auction or by a private sale. That also is specified. I have detailed slides for each of these steps which are going to there, which are a part of the entire liquidation process. Waterfall and distribution of asset. Of course, there was a lot of litigation as far as the distribution mechanism is concerned, treatment of government dues, provident fund dues. Now we have the rainbow paper. We will cover when we come to waterfall. Very important for the liquidator to understand in detail how the waterfall works. And there will be a lot of pulls and push in the stakeholders consultation committee, where lenders who have intersect different charges in terms of ranking, how are you going to handle these charges? There are various jurisprudence available on this matter, but everyone will take a different call depending on his professional understanding about the subject. And finally, dissolution of the corporate debtor. So once you have sold all the assets, settle the creditors out of the money that you have got from sale of the assets, you will have to file for dissolution of the corporate debtor. You can also do a liquidation closure in case you sell the company as a going concern, where you don't need to dissolve the company, but you need to file for closure of the process. So public notice and verification of claims, I will just run past through. What is very important now is claims which have been received and collated during CIRP shall be deemed to be submitted. I have seen a lot of professionals, and many of them during the course of my interaction, I do advise them that as a liquidator or as an RP, you have to act in good faith. So if someone has not submitted a claim, or a claim has been submitted, if you have written him an email asking for information and he has not given information, it is important that we follow up with them and try to, because if the claims are not received, finally you might have a litigation lurking at the end. So you should keep on following with the claimant to submit the document so that you are in a position to verify the claims. A lot of them say, oh, they have not submitted the claim. So during the CIRP period, the insolvency resolution process cost has to be computed by the resolution professional. So as an RP, if you say that certain costs have not come to your notice during the CIRP period, and these are basic costs. For example, if you have a property tax is one of the basic costs. I mean, you will have to pay property tax, maintenance, society dues, electricity dues, so on and so forth. If you're saying that there are no electricity dues during the CIRP or property tax, the government will have to make a claim on us. All this is responsibility of the RP. So you don't need a claim for a CIRP expense, That is the job of the resolution professional to compute and to hand over to the liquidator in case the liquidator is someone else. Or if you are the liquidator, you have computed the CIRP cost, it is your job to pay without waiting for a claim form. Because some of the professionals did argue saying that, no, unless a claim is received, you're not a claimant. So IBB has also come up with this particular clarification saying that claims received or collated during CIRP shall be deemed to be submitted, and you'd have to verify those claims and take an action on the claim. Either you accept, reject. So if you've rejected during CIRP, you again reject during liquidation, giving reasons. One of the aspect is the claim of a workman or an employee. In case a workman or an employee has not made a claim, the regulation says their claim shall be verified on the basis of books of accounts of the corporate debtors. You can't disregard the claim of a workman or an employee. One is to do with the social strata in which they are there. It's important that we facilitate submission of claims and timely acceptance of claim. Plus, the regulation has also facilitated saying that in case they have not made a claim, the liquidator is duty bound to verify the claim on the basis of the books of accounts of the corporate debtor. A stakeholder may withdraw or vary his claim within 14 days of its submission. Once the claim has been submitted, within 30 days from the last date of receipt of claim, that is 60 days from the liquidation commencement date, you will have to verify and adjudicate that claim. If you have rejected the claim or partially admitted the claim, you will have to give valid reasons as far as acceptance or rejection of claim is concerned. Any questions if any of the participants have, or I can move to the next topic?
We can move to the next one, sir.
Sure, thank you. I just took a water break. So stakeholders consultation committee, as I said in my opening remarks when I started this presentation, was earlier the liquidator was a very lonely person. You were not an orphan, but you were lonely because all these calls had to be taken by your own self. You didn't have any advice, any sounding board, and there was no mechanism for you except for a stakeholders committee. But many of them did not call for a stakeholders committee because there was no role which was prescribed. But now that the stakeholders consultation committee has been duly constituted, they have also formulated a role for the SCC to be done. So previously, in many of the cases, the lenders used to insist on an asset sale committee. So there was no regulation by which you could have constituted an asset sale committee. But then, yes, it was the basis of the request of the members. In one of my case, I did constitute an asset sale committee by calling a stakeholders meeting. This was prior to the SCC and all that, and all decisions as far as sale of the assets, the auction price, etc., was discussed mutually between the liquidator and the asset sale committee, and then we went on to publish the auction notices. Now, with the stakeholders consultation committee being a part of the regulation and also the roles and responsibilities being defined, it's quite easier for the liquidator. Previously, the liquidator could not be changed. Now, the liquidator can be changed if the stakeholders consultation committee passes a resolution by 66% by voting, and that too giving valid reasons. So as a liquidator, you have to constitute a consultation committee of the stakeholders within 60 days from the liquidation commencement date. So whom does the SCC comprise of? It says it shall comprise of all the creditors of the corporate debtor. So all the creditors of the corporate debtor, the stakeholders who have filed a claim during CIRP, during liquidation, will form part of the stakeholders consultation committee. In some cases, their representatives would be there. But most importantly, only those creditors who have relinquished their security interest. So if you've not relinquished security interest as a creditor, you are not entitled to participate in a stakeholders consultation committee, because as a liquidator, I will not allow you inside. I will not make you a part of the SCC. The voting share in the SCC shall be in proportion of the admitted claim in the total claim. Promoters, directors, partners, or their representatives may attend the SCC meeting, shall have no right to vote. So it does not mean that like a COC meeting, they are participants to the meeting. Only if the promoter, director, partner have submitted a claim which has been duly adjudicated by the liquidator and they are part of the stakeholders, then only they are allowed to attend the meeting, but they don't have a right to vote. Similarly, a financial creditor who's also a related party or their representative shall not have any right to vote. So as far as an SCC is concerned, it shall comprise of all the creditors, but some of the creditors will have to be represented by authorized representative only. Only those creditors who have relinquished their security interest and voting share. Earlier, it was prescribed that the voting was present and voting. Now it is voting. Like in a COC meeting, those who have only positive votes is what will be counted, and that will have to meet the threshold of 66%. Till the time a stakeholders consultation committee is constituted, that is within 60 days of the liquidation commencement date, the committee of creditors are going to function as the consultative committee with the same voting share until an SCC is formed. So within the first 45 days or 60 days before the SCC is constituted, to facilitate and expedite the process, the regulator has said that the committee of creditors will now function as the consultation committee. So they are a de facto consultation committee with the same voting share as they had in the COC until an SCC is formed. As a liquidator, you may facilitate the stakeholders of each class, namely financial creditors in a class. So as we understand, financial creditors in a class will not become all the banks. So this would largely be restricted to fixed deposit holders. This would be restricted to home buyers. This would be restricted to any debenture holders who are financial creditors in a class. So the liquidator will have to facilitate them to nominate their representative for participation in the SCC. So as far as financial creditors in a class is concerned, as far as workmen, employees, government departments, other operational creditors, shareholders, partners, etc., are there. They have to nominate their representative for participation in the stakeholders consultation committee. If the stakeholders fail to nominate their representative, such representative shall be selected by a majority of voting share of the class present and voting. So what generally the practice that we had followed is, we had sent an email giving the details and the email IDs. We did not give the phone numbers of all the creditors who are there in a particular class, say for example, workmen or operational creditors or government departments, and giving their admitted claims and asked them to nominate their representative. Wherever they failed, we'd given them 3 days, 5 days time, because that time we have to do that in 30 days. But now we can give them 7 days time or 5 days time to nominate their representative. In case they fail, we generally then call for a meeting of the representatives, and in that they vote. It's either show of hands or you can also open a voting window. So here it is present and voting, but everywhere else in a stakeholders consultation committee, it is not present and voting. It is in accordance with their vote share which is there. A representative shall also vote in proportion to the voting share. So if I am a representative of the operational creditors, I will have the entire vote share of the operational creditor. So I will represent the entire vote share and not only my vote share. But if I am a financial creditor, if I am a bank who's a part of the consortium, so all the consortium members will be a part of the stakeholders consultation committee, and they will have their respective voting share. The provision also says that the consultation committee shall have access to all the relevant records and information. So you will have to provide them all the information as may be required for them to provide you advice. And the first meeting shall be conducted within 7 days of the liquidation commencement date, and thereafter, as and when the liquidator seems fit or on request of any of the members, a meeting can be called. But in case members with 33% do request you to call for a meeting, you will have to call for a meeting. Like a COC meeting, you chair the meeting, prepare the minutes, record the deliberation. So all that job is left on the liquidator, and any decisions which are taken with a positive vote of 66% present and vote, not present and voting, sorry, my bad, voting. 66% affirmative votes in terms of vote share is required, and the advice of the consultation committee is not binding. In case you have a different view from what advice the stakeholders consultation committee did give you, if you take a different decision, because ultimately you are the boss, but they will also have a right to replace you, so that you should be mindful of that. But that does not mean that you take a decision influenced by the stakeholders consultation committee. In my experience, generally, I have seen them to be very rational and commercially very sound when they take such decisions. So you will have to record your reasons in writing in case you're taking a different decision, and such a decision will have to be communicated to the adjudicating authority and to the board within 5 days of the said decision. And you have to also include that in the next progress report. The stakeholders have a right to replace you. They can also replace you with 66% positive voting. So these are now the matters on which the stakeholders consultation committee is going to advise the liquidator. The word is advise and guide. It is not that they are going to decide. You can take an alternative view also. Remuneration of professionals appointed under Regulation 7. So any professionals that you would need as a part of the liquidation process to assist you, all those professionals you will have to take a prior approval from the stakeholders consultation committee. In case they refuse, you can still go ahead and appoint, but you will have to give reasons in writing. Any sale under Regulation 32, including the manner and the mode of sale, the pre-bid qualifications, what should be the reserve price, what should be the marketing strategy, uh, everything can be discussed, and in consultation with them, you can go ahead with the auction process. Fees of the liquidator can also be decided by the stakeholders consultation committee if it is not decided. By default, the NCLT orders do mention that the fees would be as per Regulation 4, but now with this enabler that the SEC can decide, the NCLT, the adjudicating authority, might also leave this decision to the stakeholders consultation committee for deciding the fees of the liquidator. Valuation under Regulation 35 is also you can discuss with the stakeholders consultation committee, and the manner in which the proceedings in respect of avoidance application. So you have this avoidance application, whereas in the IRP, RP or the liquidator, you have filed these applications asking for the money to be returned back to the corporate debtor. Now, if these applications are pending and if the liquidation process has come to a close or is coming to a close, or you are in the process of filing a closure or a dissolution, what is the manner in which this applications, who will pursue it, can the liquidator pursue it, will the secured financial? So this is something which will have to be discussed with the stakeholders consultation committee, and how the money will get distributed. So we've done this in 3-4 of our assignments also, where it was discussed that one of the secured financial creditors would take the lead, or they would appoint any agents to take forward these applications. So these applications are not very simple. I mean, you can get an order. So assuming the RP had filed an avoidance application as a liquidator, you pursued that avoidance application and you have got an order. So if you've got an order, it is also your duty to recover that money so that that comes as a part of the liquidation estate, and that can be distributed to all the stakeholders. Now, recovery of this money is also an important aspect for the liquidator, and he will have to take all those steps to recover this money. However, if you've sold all the assets and the recovery has not happened, or if the application itself has not been disposed of, because in my experience, even if the application is disposed, if you have an order, recovery might take a long time. In one of the first cases that I handled in liquidation, which the order was passed, we had filed an avoidance application and we had also got an order. Now, this order was given to us by the adjudicating authority. It was an ex-party order. So we wrote to the persons asking for the money. They did not give any funds. So no funds were credited by them. We kept on writing follow-up emails, calls, but nothing happened. They thought nothing would happen. So we went back to the NCLT after 2 months saying that this is an order passed by your lordships. We are unable to recover this money. So then the NCLT gave them a timeline of paying the money within an X amount of date. Now that money also did not come even after that order was passed, and thereafter we proceeded to file contempt of court against this. But because of COVID, it took a long time. And finally, when these regulations came in, the NCLT said, "Why don't you assign this as a not readily realizable asset?" So we tried assigning it also as an NRRA. We were unsuccessful because the amount was quite small. Finally, under this regulation 44A, we assigned this to the secured financial creditor. And now that the dissolution order has been passed, they will be taking ahead this particular matter ahead. So recoveries will happen, should happen, but someone will have to take responsibility. And the stakeholders consultation committee would be in a better position to guide the liquidator on what exactly needs to be done. Any questions?
Sir, I have a question.
Yes, ma'am.
You mentioned that the liquidator now can be changed after a valid reason and the stakeholder committee will approve. So should NCLT be intimated about it?
The application would be filed with the NCLT, ma'am. Ultimately, the decision of the stakeholders consultation committee by way of an application will be filed with the NCLT. The NCLT is going to hear the petition. It may also hear the liquidator who is proposed to be changed, and accordingly, they would pass suitable orders.
Okay. In case of voluntary liquidation case, sir, is there any change? Voluntary liquidation case.
No, there is no change. But since you've been appointed by the AGM, you can actually call for a general meeting. The same process, and because I've not done any voluntary liquidation cases, ma'am. But since the general body had appointed you as the liquidator, you can again go back to the general body and they may appoint someone else.
Okay. Okay. And
I don't think there is any further compliance as far as a voluntary liquidation is concerned.
Okay. Who can chair the committee, stakeholders?
The liquidator.
Anyone else can be done? Just wanted to know.
No, the regulation does say that the liquidator will chair. So anyone else would mean whom, ma'am?
Okay, I get that. I get that. Correct.
Yeah.
And
so you can't tell any of the stakeholders to chair the meeting on your behalf. Of course, you may delegate it, but you'll have to also be cognizant that IBBI may come after you saying that you've delegated. But if there is an emergency and you can't help it, I mean, it may happen. But that's not advisable. I won't advise that.
Okay, thank you.
Oh, so one question.
Yes, ma'am.
So like 90 days period is too small considering all these PUFE transactions, orders from NCLT generally takes a lot of time. So, and if we try to follow up these orders, so how much possible is it that these proceedings are completed in this period of 90 days and how the extensions are taken?
So as far as 90 days is concerned, there is no restriction of a 90-day for closure of a liquidation process. You will have to close a liquidation process within 12 months. So that's what the regulation says in terms of forced liquidations arising out of failure of CIRP. So that is where you will have to do. So I understand your question. It takes a lot of time, and that is where these regulations have come. So if in a corporate debtor, you've sold all the assets and you have to close that within 1 year's time. Let me give an example of one of my last cases that I have done. I sold the asset in the 3rd month of the liquidation commencement date. Within the next 45 days, we got all the money. We distributed the money and we filed for closure. And we also took permission from this from the stakeholders consultation committee that this avoidance application, this was continuing for the last 1.5 years, that this would be taken ahead by the secured creditors, any of their representatives. Now, the timing of this particular takeover is very important because till the time the dissolution order is not passed, it is the duty of the liquidator to pursue these applications or recoveries. However, if the dissolution order is passed, so you should say, should a dissolution order is passed. So whenever you're passing those resolutions, you say, should a dissolution order be passed, any one of the stakeholders or anyone who's identified can take over these applications for the benefit of all the stakeholders. And the proceeds of this distribution would be done in accordance with Section 53. If you look at the last line and the manner in which the proceeds from these proceedings shall be distributed, it's always advisable to write this will be distributed in accordance with Section 53, because today we have a rainbow, tomorrow we may have some other judgment, right? So it's always better to say that all these proceedings would be distributed in accordance with Section 53. Right. I hope I've answered your question.
Thank you so much.
I have a question.
Yes, sir.
Yeah. After filing the dissolution application or after closure of things, what we do about the record of the corporate debtor? Like we have a huge, in my case, I have a huge documents of corporate debtor, not the liquidation process, the corporate debtor record, the old records.
Right, sir. So If you look at the regulations, they say that the liquidator has to preserve the records of how the process has been conducted for a
Right.
period of 8 years. Now it again begs that question that what do you do of the other old records if tomorrow the enforcement agencies or anyone comes and asks for these records,
Right.
because you are the custodian now. So it's advisable, and that's the market practice, that you generally deposit all these documents with one of these data security providers. There are a lot of firms which are into this, which are going to take your documents,
Okay.
store them for 8 years, and in that agreement itself, they will say we will destroy on our own self after 8 years, and you pay them in advance. So that is what I've done in at least two of my cases. That's what
Okay.
I've
Okay.
done. So you can, because see, I mean, who is going to take that load? There is no clarity.
Right.
The best thing is to destroy the documents, but no professional is going to take that risk. So spend some more money. You are any which way going to preserve your own records for 8 years. So along with those records, you preserve this records and give it to a data warehouse provider. There are quite a few, and pay them up. That's it.
No, preserving our record, our process record is our duty. We can pay for that. But for the corporate debtors record, the earlier record, can we put that expense into the liquidation cost?
In my view, even your records you can put, but you'll have to do this prior to this. So I'll give you an example. If you are handling a live assignment, see, if you have 5 files, then it doesn't make sense, right? There are some assignments where there may not be more than 5 to 10 files, but if you are running an infrastructure EPC company
Right.
for 2 years, 3 years, there are multiple records which will be there. There would be hundreds of files which you yourself will generate during the process. So you can actually keep those also with the data service provider.
Okay. Thank you.
Sure, thank you. There was one question on the chat box, whether timeline for completing liquidation within 360 days is strictly applicable to voluntary liquidation too. In voluntary liquidation, time exceeds. So we'll come to the voluntary liquidation, sir. I will answer that question at an appropriate time. So preparation of a liquidation estate. So as I've earlier said, that liquidation estate is very important. If you've seen a recent disciplinary order, one component of the asset was not taken as a part of the liquidation estate, and the RP had to face consequences. You can read the order on the IBC website. It just uploaded in the last 2 or 3 days. So some things you may miss. There may be an oversight, but if you are the RP and you are continued as the liquidator, it shouldn't happen that if you have missed anything. So all the assets which are there in the company over which the company has ownership rights, whether in your possession or not, they are all part of the liquidation estate. So I am handling an EPC company where we had projects, assets across 32 sites in the country. So all these sites were not owned by the corporate debtor, because under an EPC contract, you also had to put, apart from men and material, your own fixed assets also. So all these were lying at the various assets. So we had to take care about the insurance, the security, so on and so forth, and appropriate documentation. So whether the assets are in your possession or it's in the possession of a third party or it is with a third party, all these assets are a part of the liquidation estate. In another of one of my cases, when I took over as the IRP, I learned that some of the assets, one of the suppliers had kept in a warehouse because the company had not paid. Now, in this particular instance, we wrote to the particular supplier because majority of his amount was paid, only 25-30% was not paid. But these were highly big assets, almost 30-35 crores worth of assets. So we wrote to him saying that I am the IRP, this is an asset of the corporate debtor, and you will have to give it back to me. Of course, with some back and forth, they gave the asset, they handed over all the asset to us. So any asset over which you have a title, you have a possession, it is there in the records or it is there in the balance sheet. These are assets of the corporate debtor. To give you another example, for example, a car. In most of the companies that you see, the car is in the personal name, but it is put in the name of the corporate debtor because they want to take depreciation, and all the money is also paid. If the loan is also taken, it is paid from the accounts of the corporate debtor. So even in the car is in the personal name, the car is an asset of the corporate debtor. You can basically either recover the money from them, or you can treat this as a part of the a liquidation state. This can also be a part of the avoidance application, saying that this is what has happened. Many of the times you can also get an NOC from the director or the promoter in whomsoever the name of the asset is, saying that I have no objection, as when you sell, you can recover the money and I will sign the transfer form. So all these also can be done. So very important for us as professionals is to understand what is the liquidation estate, what are the issues arising out of liquidation estate, value recovered through proceedings for avoidance of transactions, so on and so forth. Even assets which are subject to determination of ownership by the court or an authority. So in the case that I gave an example, we had a dispute as far as the asset was in my name, but there was a dispute on account of the sale consideration. So that was finally subject to the determination by a court or an authority, but it's a part of my liquidation estate. Although it's not in my possession, I don't have possession today, but there is a status quo as far as the asset is concerned. So it is in the possession of the third party. However, I have included that in my liquidation estate. In the liquidation estate, I have highlighted over here any asset of the corporate debtor in respect of which secure creditor has relinquished security interest. If a secure creditor wants to sell his security on his own, he should always be more than happy and willing to give it out. Just to give you an example now, if I am a secured creditor and I have the asset and I have 100% charge on this asset and I'm a first charge holder. So if I ask for the asset to be sold under section 52, that is I will realize on my own, the liquidator has to verify my claim, verify the asset and hand it over to me. So that is the process. But wherever there is a consortium and multiple lenders have a charge, multiple creditors have a charge on a single asset, then the threshold is 60% value. So if there are 10 creditors with 10% each, so if say 70%, 60% of them are 60% is the threshold. So if 60% give you relinquishment, saying that, okay, I am willing to do this in favor of the liquidation estate. So if it is more than 60%, you can sell it. So you don't need the approval of 100% of the secured creditors who have a charge. If by value more than 60% you get it, it will become a part of the liquidation estate and you can sell it, even though the other lenders have not. So in one of the case, we had a consortium where some of the lenders who are almost 15-18% did not approve this. And in every stakeholder meeting, they kept on saying that, no, we have not allowed this, we have not allowed this, kindly record this. And I kept on saying that what you would have done. Let's assume I would have given this to you with 18% and I have 82%. You would have sold it under SurfaceE. I would have blocked it, right? So there was no other way of selling this than looking at that 60% threshold, because according to them, that 60% threshold is not mentioned in IBC. However, there is an NCLT order. I forget the name of the company, but there is an NCLT order on a very similar aspect saying that if creditors more than 60% relinquish in favor of the liquidator, it is deemed to be 100% relinquished. As far as exclusions are concerned, so whatever asset is in your possession, but it is owned by a third party, those are obviously not assets. So if you had a company which was into contract manufacturing and the raw material was supplied by some supplier and your job was only doing conversion or a tolling agreement, so the assets were never never your ownership. So these assets belong to a third party, although they may be in your factory lying within your premises. These are not assets in your liquidation estate. One important aspect to recollect and remember is hypothecation. So hypothecation of movable assets, generally hypothecation means a floating charge. So hypothecation on the stocks means I can deal with the stocks on a daily basis. In the case of a mortgage, I would need a prior NOC. In the case of fixed assets, movable assets, I would need a prior NOC. But can I churn fixed assets on my own as a borrower? Yes, in the normal course of business, I can do that. So I had a machine which is obsolete. I sold it, I bought a new machine. So obviously when the new machine came in, since the lenders have a floating charge, they will have a charge on everything. So hypothecation of assets would mean a floating charge. That may not mean that all the assets lying in your premises are charged to the secured creditors of the corporate debtor. For example, if there is a third party crane which is there in your premises and you would say, okay, since it is there in my premises, you will have to check with and verify whether these assets belong to the corporate debtor or not. If they don't belong to the corporate debtor, then in that case, you will have to hand it over to a third party who would come with his documents. Once you verify the documents, thereafter, you can hand it over. Any personal assets of any shareholders, etc., also will not be a part of the liquidation estate. Any assets of any subsidiary is also not part of the liquidation estate. So any Indian subsidiary, foreign subsidiary, subsidiary companies, the shares are your property as a part of the liquidation estate. The assets, you can't have a control on the assets of a subsidiary company or an associate company or a joint venture company. Even if it is a 100% subsidiary, you can't touch those assets, you can't sell those assets. You can exercise your right as a shareholder and you can sell these shares as a part of the auction process. The liquidation estate is held by a liquidator as a fiduciary toy for benefit of the creditors. I had briefly touched upon the subject of relinquishment of security interest. So I just wanted to draw your attention to 2-3 regulations. One is Regulation 21A, presumption of security interest. Earlier, when the liquidation processes did start, we were to wait for the secured creditors to relinquish security interest in our favor. So until and unless they did not relinquish security interest, I used to sit. I could not do anything because neither have they exercised their rights under Section 52, nor have they exercised their rights of relinquishment. So the only lame excuse we were to hear was this has been sent for approval. As and when we get an approval from our higher ups, we would relinquish this. We don't want to sell. You can sell, but this is taking time. So there were cases where for 7 months, 8 months, almost a year, liquidators were sitting without doing anything. However, there was one NCLT order of the Mumbai bench in the case of Avil which said that once a creditor has filed a claim and 75 days has elapsed, then it's a case of deemed relinquishment. What is the significance of this 75 days? Within the first 75 days, many of the participants would be aware that the liquidator is supposed to file a preliminary report and an asset memorandum. So these are the two things that you are supposed to file with the Honorable NCLT. So if a lender has not, if a secured creditor has not relinquished his security interest, you would have taken that asset in the asset memorandum with a note saying that we are still awaiting a realization. However, since they have also not exercised their option under Section 52 to sell on their own, this would be a part of the liquidation estate. But the regulations underwent a change, and now the regulation says that within 30 days, a secured creditor will have to elect whether he would sell on his own or he would relinquish it in favor of a liquidator for the liquidation estate. So this is something now which has to be done within 30 days. If this is not done within 30 days, then it is a case of deemed relinquishment. So Section 20, Regulation 21A is very important. I'm sure many of the participants, liquidators, would be aware. Now, if a secured creditor who decides, what happens if he decides to sell the security on his own, realize the security interest on his own? So if a secured creditor decides to realize security interest on his own, what he will have to do is first is to make an application along with the claim form. He will have to inform the liquidator whether he wants to realize or relinquish. If he says realize, the liquidator is duty bound to verify his claim, verify his asset, verify his security interest, and accordingly hand over that asset to him. Now, if on that particular asset, if someone has a second charge and an ex-lender who has a first charge, sole first charge, has called for realization on his own. So in my opinion, and that what we've also done is handed over the asset to the first charge holder and also intimated the second charge holder that this request has come and we have handed it over to the first charge holder. So if any recourse is there, he can, of course, exercise his recourse separately with the particular secured creditor. Now, earlier, when this Section 52 said that a secured creditor who elects to realize security interest on his own, he will have to pay his share of insolvency resolution process cost. So that is something which was computed by us as liquidators and given to him, saying that, okay, you are wanting to sell your asset on your own for whatever reasons, this is your asset, please take and sell this. Along with this, you will also have to pay me insolvency resolution process cost, your share towards the insolvency resolution process cost. So that is something which will have to be computed by the liquidator. It's an estimated amount, and you were to give it to the secured creditor. The secured creditors in a lot of cases did contest this, saying that this is not payable, or the calculation or the methodology was being contested. But now the regulation makes it very clear under 21A that within 90 days from the liquidation commencement date, the particular secured creditor who decides to realize security interest on his own will have to pay his share of the CRP cost, his share of the liquidation cost, and the share in the amounts payable to workmen. If you realize section 53(1)(a) talks about insolvency resolution process cost and liquidation cost to be paid in full. Thereafter, workmen for 24 months in proportion to the secured creditor claim. So that's what the regulations say. Within 90 days, you'll have to pay three things: your share of CIRP, your share of liquidation, and your share in the amount payable to workmen, regardless whether you sell the asset or not. It is not payable when able. It is your duty to pay this amount regardless the asset is sold or not, money is realized or not. Within 180 days of the liquidation commencement date, the asset which you have decided to realize has a value more than the value of the debt. For example, the value of the security is 100 and your debt is only 40. So 60 is something which is the excess. So that 60 will have to come back to the liquidator. There was no timeline for this. Now section regulation 21A makes it very clear, 180 days. Within 180 days, regardless whether you sell the asset or not, the excess value will have to be transferred to the liquidator's account. In case you don't do this, this will be a case of deemed presumption of security interest. Deemed relinquishment is something which will have to be presumed, and this will become a part of the liquidation estate for a liquidator to sell. So very important to keep that in mind. If a secured creditor wants to sell on his own, within 90 days, you have to recover share in CIRP, liquidation, and the amount payable to workmen. You can compute this amount. This may be an estimated amount. This can be finalized later. The regulation does provide for all these scenarios, saying that it can be computed on an estimated basis, and thereafter, once the final confirmation comes, the balance money will have to be given. But in case it doesn't give within 90 days or 180 days, then it's a case of a deemed relinquishment, and it will be a part of the liquidation estate for the liquidator to sell. Sale of assets, again, regulation 32 covers what has been covered in section 36 of liquidation estate, which says that where an asset is subject to security interest, it shall not be sold until it has been relinquished. Interestingly, section 77(3) of the Companies Act also says that notwithstanding anything contained in any other law for the time being in force, no charge created by a company shall be taken into account by the liquidator or any creditor unless it is registered. So every charge will have to be registered with the registrar of companies, and unless it is registered, it will be void against the liquidator. The liquidator is not going to consider any security interest for which a charge on the assets of the corporate debtor is not created. So it's very important for any creditor who has taken any security belonging to any corporate debtor to register a charge. It was very common practice that cars which were financed by a lot of these car companies or even by banks, they never used to create a charge in the ROC. So I also had a very interesting case where one of the lenders had a vehicle which was hypothecated to them. The charge was created in the Vahan, which is the site for the registration of vehicles. So the charge was being shown there, but it was not shown in the ROC. Now, if you look at the regulations, which talks about security interest in a liquidation estate, it says the charge will have to be substantiated by a charge recorded in the ROC, a charge in the SARSAI, as far as security interest is concerned. So when we wrote back to this particular lender saying that either show me proof of registration of ROC or show me proof of SARSAI. So they came back with a circular, and the circular came somewhere in April of 2021 or maybe 2019, saying that there was a notification issued by the government saying that any registration of a vehicle which is done under Vahan will be deemed to be a registration under SARSAI. So SARSAI covered vehicles registered under the Motor Vehicles Act. So basis this, we handed over them the vehicle and they sold their vehicle, and the proportionate share of the CRP cost also they had shared with us. So these are some of the important aspects which participants will have to take care as far as security interest liquidation estate is considered. Any questions? So I'll move to the next topic, which is reporting by the liquidator. So reporting by the liquidator shall prepare and submit to the NCLT following. He should submit a preliminary report. A preliminary report has to be submitted within 75 days of the liquidation commencement date. It will have details about the company, its capital structure, the estimates of assets and the liabilities, whether the liquidator intends to do any further investigation. So this is a very comprehensive report which a liquidator will have to file in terms of the background of the company, the assets and liabilities which are available, the intention to investigate the company. If the resolution professional has already investigated the company and filed applications, you may make a submission saying that I will continue those particular applications. Plan of action: how do you plan to liquidate the assets of the corporate debtor, and what are the timelines along with the estimated liquidation cost? So estimation of liquidation costs is a very important criteria, especially when the company is a going concern with a lot of operations. If it is a company which has very limited operations, or if it's a manufacturing setup, you can with some reasonable clarity estimate the liquidation cost. But infrastructure companies, in my experience, are very difficult in terms of estimation of liquidation costs. So preliminary report is a very comprehensive report which has to be submitted within 75 days. The next report is the asset memorandum. This is basically to a large extent subset of the asset memorandum, because here also you'll have to give an estimate of the assets, your plan of action to sell the assets, and the estimated costs that you are envisaging as a part of the process. So as a liquidator, you will have to form a liquidation estate and submit the report within 30 days or 75 days of the liquidation commencement date. So when I had explained the slide on appointment of registered valuers, if you decide to continue the same valuers which you had appointed during the CIRP period, then you have to submit this report in 30 days because you already have a report. If you wish to engage fresh valuers, or if the COC wants you to do a fresh valuation, or not the COC, the SCC wants you to fresh valuation and you agree to their request, or there is no valuation which has happened during the CRP period, then within 7 days of the liquidation commencement date, you will have to appoint valuers. And once you appoint those valuers, they will have to submit the report, and within 75 days, you will have to file the asset memorandum. So 30 days where you will rely on the valuation done by the valuers during the CRP period. Where you go for an independent valuation, a fresh valuation, or if the valuation has never been conducted, then it is 75 days from the liquidation commencement date. You will also have to provide details on the value of the assets and the manner in which you intend to sell the asset, whether it's a standalone basis, lump sale, set of assets collectively, assets in parcel, corporate debtor as a going concern, business as a going concern, and how do you plan to sell it? Do you want to do a private auction, or do you want to do a public auction? Ordinarily, it is advised that you only do a public auction, and that's what, even if you go to NCLT in some of the cases, asking for permission for private auction, they are going to ask you the question, and most of the councils are also going to advise you that it's always better to do it in a public auction in the interest of transparency. I'm not saying that a private auction is not transparent, but there will be a lot of questioning as far as the NCLT is concerned. But if you're quite confident that value maximization would happen only in a private sale, then of course go ahead and file an application with the NCLT. As far as sharing of this asset memorandum is concerned, liquidators shall share the asset memorandum with the board and the SCC members having a voting right after taking confidentiality agreement. Previously, prior to the amendment in the regulation, the asset memorandum was not to be shared with any participant. So we were not sharing the asset memorandum with any of the secured creditors, but now it says that you have to share the asset memorandum with IBBI, the regulator, and SCC members who have voting rights. So anyone who has no voting rights, you will not share anything with them. Progress reports are periodic reports which a liquidator has to submit. The first report has to be submitted within 15 days from the end of the quarter in which you are appointed. So today we are on 9th of June. So if I'm appointed today, the quarter ends is April to June. So 30th June is when the quarter ends. So 15th July is the first report to be filed, and thereafter subsequently every quarter 15 days after that is what you'll have to file. So whatever you do during the course of the first 3 months or the first progress report, so the entire history of what you have done, the activities that you have done, and the activities that you propose to do, that is something which you will have to mention as a part of the progress reports. Earlier, NCLT Mumbai was not hearing progress reports, but now they have started hearing progress reports. So these have to be filed, and you will have to make representation and explain them on what are the issues and why liquidation is taking time, or if the liquidation is on track. You'll have to inform them that the liquidation is track, and it is expected to be closed within the next, say, 1 month, 3 months, or whatever the timelines. As far as the report of the fourth quarter is concerned, which is the Jan to March, the financial year closing, it will also include audited accounts of the statement of liquidators, receipts, and payments. So what will need to be submitted is a statement of liquidators, receipts, and payments of the liquidators account. You don't have to submit audited financials. You will only have to submit the bank account receipt and payment that will have to be audited. Once an asset is sold, you will also have to submit periodic progress reports with the details on sale of assets. So asset sale report will only be submitted along with the progress report in the quarter in which the asset is sold. Minutes of consultation with stakeholders and minutes of consultation committee, that will have to be filed in the prescribed format, and that will also have to be submitted along with the progress reports. Once the dissolution is complete, that means all the claims are verified, the assets are sold, the money is distributed in accordance with Section 53. Then you will file a final report prior to dissolution. You will file a compliance certificate in Form H, and you will also file a dissolution application or an application for closure of the liquidation process. So this is to be filed once all the assets are sold, all the amounts have been paid off. There is nothing much in the company to do. You can file this application, and the NCLT would hear this application. Unless you close the bank accounts, they do not pass a final order. So you'll have to close the bank accounts, and thereafter only you will have to file this application so that the NCLT can pass dissolution orders. You have to maintain registers, receipts, books. As one participant asked a question, what do you do about the records of the corporate debtor? As far as corporate debtor is concerned, it is advisable. Of course, it's not mandatory. Different professionals may take different calls, but to be conservative, we generally store them also for a period of 8 years. Any questions? No questions. Fine. So we move on to the next one, the manner and mode of sale of assets. So maybe in the next 15 minutes, we'll take a break at around 4 o'clock, maybe for 10 minutes if the supervisors allow, and then we will move ahead. Manner and mode of sale of the assets. So manner of sale would be standalone basis, lump sale, assets collectively, parcel, sell the CD as a going concern, sell the business of the CD as a going concern. So if you intend to sell in any one of these capacities or in any one of these heads, then you have to get the valuation done accordingly. Compromise or arrangement has to be done within 90 days of the liquidation commencement date if proposed. If it is not proposed, you can straight away go ahead with your liquidation process. And if at all it is proposed, the regulation does seek for a time of 90 days. In case it goes for beyond 90 days and there is a failure of the compromise or arrangement, you will have to file an application asking for exclusion of the time, because thereafter, because it only says 90 days, so you can exclude that time and thereafter start the sale of the liquidation process. So this will ensure that your fees are protected and not affected on account of delays in the compromise or arrangement, or failed compromise or arrangement. If the compromise goes through, then now the fees can also be decided by the stakeholders consultation committee. Of course, the regulation says that in case it is not decided, you will be entitled to the same fee as the resolution professional was drawing. Sale as going concern. So the regulation also talks about sale as going concern, and as a liquidator also I would advise many of the participants who would be liquidators or would take up assignment as liquidator, sell it as a going concern. That's one of the quickest and the easiest way to close a liquidation process. If you start selling the assets piece by piece, I mean, you can do that also and realize, of course, it will take a lot of time if you have multiple assets, and it will also lead to a lot of processes that you will have to do. So the best thing is to try and sell the company as a going concern. Now, since this was also an easier option, the regulator by amendments in the code 16 September 2022 has come up saying that you can only do this exclusively once. So sale as a going concern can be done exclusively only at the first auction. So does this mean you can't do sale of the CD as a going concern? So if it fails the first time, can't you do it the second time? The answer is you can do it, but you can't do it exclusively. So if you've looked at some of the auction notices that have come, and this was a practice which many of us also followed, we gave option A, option B, option C, option D, option E. So option A was always sale of the CD as a going concern. That was the first option. If that fails, I will sell this under option B. I might sell a particular parcel of machinery, movable assets, or properties separately. If I have 3 different factories, I can put them differently also if the sale as a going concern fails. So as a liquidator, you will be in a better position to understand. Please do not do this auction notices mechanically. You will have to apply your mind, because your job is to sell the asset as expeditiously as possible. And to maximize the value, you will also have to look at opportunities where maximum value is derived. You are also the best person to guide the stakeholders consultation committee on what the asset is, how the asset is, what is your experience, and what do you feel. So since being the person on the ground, the liquidator is someone whom the stakeholders consultation committee is going to listen to seriously, and your views will also be taken by them. As far as sale of going concern is concerned, the regulation talks about grouping of the assets and the liabilities as identified by the COC as per regulation 39C. So many of the liquidators in some of the forums also we had this discussion and debate in terms of what about liabilities. So most of the liquidators still today, as I understand, say that even all the liabilities will have to be paid by the auction by the bidder, and he will have to go to NCLT to seek any waivers. According to me, that may not be an appropriate way, because section 53 is very clear. Even the NCLTs have now been questioning, saying that why the liquidator is asking a bidder to file an application for reliefs and concession when section 53 is 53 is very clear. From the proceeds of the liquidation estate, it is the job of the liquidator to sell all the assets. However, there may be other reliefs and concession which a bidder may want. For that, they may file with the Honorable NCLT. Now, who will file the application for reliefs and concession? Is it the liquidator who has to file, or is it the successful bidder? Both of you all can file. The liquidator can also file, the successful bidder can also file, but generally we advise that it is always the successful bidder who should file, because as a liquidator, I do not know what reliefs and concessions you want. So it is better that you file the list of reliefs and concessions that you are seeking with the Honorable Adjudicating Authority. You can make me a party, and we will submit our submissions at the appropriate time. So it is better that the bidder submits for reliefs and concession. There are a lot of reliefs and concessions apart from extinguishment of all liabilities, but liabilities which can be given as a part of going concern. I will give you an example. For example, today is 9th of June, and my security bill will only come at the end of the month. So this is a liability which is a going concern liability. A GST payment will have to be done next month. A TDS which has been deducted, statutory payment will have to be done next month. So these are liabilities which are essentially liquidation costs. So these are liabilities you can pass on as a going concern, but not liabilities prior to liquidation commencement date. You can't pass on those liabilities because that is neither the intention of the code nor is it practically and feasibly possible. So sale of going concern is a very preferred option because it helps you in closing the liquidation in a very fast and expeditious manner. Any questions on this? Sale of asset, mode of asset. So ordinarily, Schedule 1 would tell you that the sale of asset should always happen through an auction. Private sale is also possible, but there are certain conditions under which a private sale will have to be done. So at an auction, as a liquidator, you have to prepare a strategy on how are you going to sell the assets. You'll have to reach out to potential bidders, try to market the asset. Then only the asset is going to get sold. If you're only going to give a public notice, an announcement in the newspaper, and expect participants to come in and submit their bids, it may be too much to ask for. So it is the job of the liquidator to create an appropriate marketing strategy as far as sale of the assets is concerned. You will also have to prepare the terms and conditions at which the auction will happen. What would be the reserve price, earnest money, any pre-bid qualification, so on and so forth. So the reserve price is also discussed and decided in consultation with the stakeholders consultation committee, and it would always be advisable that it should always be done amicably in agreement with the stakeholders consultation committee, because if you both start fighting, the matter would end up at the honorable adjudicating authority, and it will take a long time to resolve the matter. Once an auction fails at a particular reserve price, to what extent can you reduce the price? You can reduce to a maximum of 25% in an auction failure. This also has to be discussed with the stakeholders consultation committee. Generally, I have seen most of the secured creditors financial institutions will not agree to a 25% at the first instance. They generally agree for 5, 10, maximum 15. I mean, convincing them beyond that would really test your skills. So the reserve price can be reduced at the first instance in the first failure by 25%. Thereafter, not more than 10% at a time. So you can't falter on these regulations. It's always advisable to refer to the regulations whenever you're doing any activity under the code. Once an auction is successful, the balance consideration will have to be paid within 90 days. First 30 days, there is no interest. Thereafter, it will attract an interest of 12% per annum. Can you waive the interest? The answer is no. Can you extend time after 90 days? The answer there again is no, because there have been numerous judgments of the NCLT and the NCLAT which has held that no further extension can be given because it is not allowed. So any bidder would want extra time. Generally, I would say no, because it is not within my power. It is not also within the power of the stakeholders consultation committee, because they are only there to advise you. Even if they advise and you take the decision, you will be held responsible, because you could have taken a different decision and recorded your reasons in writing. So if the stakeholders would say, okay, give another 30 days after 90 days to the party, you may disagree. Even if they vote for it, they will not do it. But in case they do it, you can take a different view and record your reasons in writing. As a liquidator, you also have the power to execute sale deed and transfer the entire formalities only on receipt of full consideration. Can you do a private sale? Yes, you can do a private sale if the assets are perishable or they're likely to deteriorate in value if you don't sell this immediately. If the asset has failed in an auction, so if the last auction was for 100 and now someone comes and offers you 101 or 102 or 110, you can accept that and move ahead. If he comes and offers you 99, 98, 90, you can't do that. So what you can only do by way of a private sale is price higher than the last price of the failed auction. So you would also ask a question, who would do that when he knows that at 100 the auction has failed? The next auction presumably would be at a discount, if not 20%, at least a 5%, 10% discount. But generally, it's my own experience also, and that's what I tell some of the bidders when I try to sell them or convince to sell them at a private sale is, even if the auction at 100 has failed and the next auction comes at 90, I have in my own cases experienced in the subsequent auction, the price has gone beyond 100. I've been able to recover 105, 108. That may also be because of less marketing. People who are not interested may be interested now. There may be many factors. You always sit and decide, contemplate and brood over after an auction on what went right and what went wrong. If the auction failed, then also you start asking yourself the question that did I not market enough? Did I not reach out? Was the price not right? So even if it is successful, you may have to answer certain questions because sometimes the auction may exceed your expectation. We had a lot of people early on saying that, okay, I put an auction at X, it went at 3X. The question is, was the valuation wrong, right? You can also play the devil's advocate. So at every auction, whether it fails or it succeeds, you'll have to ask those questions to your own self. Only if only one bidder has come and he has bid for it. Had two bidders come, and there could have been more participation. So as a liquidator, your job is to start thinking and trying to maximize the value of the asset, trying to sell the asset. But yes, a private sale is allowed. A lot of private sales do happen, and people are willing to pay more than the last failed auction. They won't pay you substantially higher. Maybe a token amount is also something which is acceptable so that you're within the guidelines and the regulations. If at all there is a collusion amongst the parties and you understand that there is a collusion and the asset may fail, because a lot of these auction processes, there are a lot of these brokers who would try to enter the process. I have seen cases where I have put some scrap material at 5 lakhs, the value has gone to 60 lakh rupees with no intention because he only had 50,000 to lose. At stake was only the 10% EMD that he had submitted. So that's an extreme, but there may be cases where there is collusion amongst the parties trying to drive down the prices. In such cases, the liquidator will not proceed with the sale of the auction and he will seek appropriate NCLT orders against any colluding parties. I have not come across any order to give an example for this. And assets will be sold only to those persons who are eligible as resolution applicants. That means Section 29A is applicable. You cannot sell assets to a person who is not eligible to submit a resolution plan. So you have to do a 29A check. At most, what we do is we rely on the affidavit which has been given by the bidder. If you feel it is suspicious or if you have reasons to doubt, you may get a 29A check independently prior to the auction, or even after the auction before the sale consideration, or even if the letter LOI is issued, you can do a 29A check and take action according to the findings that you have there. Now, what are the other key points as far as the auction process is concerned? The public notice has to be done within 45 days. So the regulator has made it more and more tough for liquidators to sit on assets. You can't sit on asset any longer. You will have to put it on auction within the first 45 days of the liquidation commencement asset, unless the SCC has advised you to extend the timeline. So the SCC says, okay, we will set it at a later date, then it is fine. Otherwise, you will have to do first auction or you will have to face disciplinary proceedings from the regulator or the IPA. If an auction fails, next auction you can't wait for 2 months, 3 months, 4 months. We used to do earlier, we used to sit on assets and look at people, because mechanically only putting notices after notices is not going to serve the purpose. I mean, do 10 notice and keep on reducing the price. A value of 100 may come down to value of 40 in the next 8 to 9 months by doing a mechanical auction. But what is more advisable is take approval from the SCC to deviate from the timelines if you feel that doing an auction at 15-day interval may not help. So it's up to your professional judgment and the stakeholders consultation committee, whatever you all decide. An auction process also has to be completed within 30 days from the date of the issue of notice. So you cannot keep on extending the timelines. You have to complete it within 30 days. You have to give minimum 14 days from the date of issue of notice for submission of eligibility norms. The reason why I'm getting into these timelines is because I've seen 2-3 disciplinary orders in the last at least 3 to 6 months. I'm also aware about certain cases where the way the auction process was conducted by the liquidators left a lot of questions to be answered. For example, in one of the notices that I saw, the notice was issued on a Saturday, and the last date to submit the EOI document was a Monday, and Tuesday was the date to make the payment. And the auction was 2 days later. 7 days for an auction value, the value of the asset was 13 crores. So the question is, you also think to yourself, why more time could not be given, right? Even another case where I saw a disciplinary order, very similar thing was done, that all the timelines were crashed to less than a week. So ideally, you should give a lot of time, maybe a lot of time, no, but you should stick to the regulations to the minimum to ensure that time is given to bidders to participate in the process, evaluate the asset, do their due diligence, and thereafter decide to participate. If they decide not to participate, that's fine, but it's your duty to give them more time so that at least all due diligence is done. So these timelines are very important. EMD cannot be more than 10% of the reserve price. You can't have a 20% or a 50% EMD. You can't block certain participants. So the 10% is what now the regulation says. You cannot take any non-refundable fee or participation fee, etc. The physical auction, if at all you have to do a private, will have to be with the prior permission of the NCLT. And you cannot reject any bids outright. If you reject a bid in an auction process, then you have to intimate the reasons for such rejection, and you have to mention that also as a part of your progress report in the subsequent thing. Any questions on this? Can we take a break of maybe 5-10 minutes, if that's allowed? Or should we continue? Whatever.
Yeah, you can take break.
We can take a break, 15 minutes, 10 minutes, whatever.
I think let's take it to 10 minutes. 10 minutes should be fine.
Okay.
Sure, a 10-minute break. Thank you, everyone. We'll join in 10 minutes. Yeah, hi, good evening. We can start. Am I audible?
Yes, sir.
We can start, ma'am. I think 10 minutes are done.
Yes, sir, you can start.
Yeah, hi, good evening and welcome back. So we've looked at the liquidation estate and we've looked at going concern sale. So I thought I'll also cover the treatment for sale of some of the very peculiar assets and receivables. One is assignment of not readily realizable assets, regulation 37A. This was also amended by way of regulations. So the regulation 31A says that a liquidator may assign or transfer a not readily realizable asset through a transparent process in consultation with the SEC for a consideration to any person eligible to submit a plan. So this essentially is, sorry, I will put on my video also. So this essentially means that an NRRA, a not readily realizable asset, will have to be sold in a transparent manner. In a transparent manner would be an option. So what constitutes an NRRA? So it constitutes certain assets which are not readily realizable, which might take some time. For example, a preferential, undervalued, extortionate avoidance application, their recoveries will take a lot of time. There would be certain receivables arising out of contracts. Now, some of these receivables will have, these contracts will have to be closed, documents will have to be submitted, and sometimes most of the government entities, especially in EPC and infra companies, they take a lot of time. Some of these contracts are done over a period of 5 years. It's not like a manufacturing company which has supplied a goods or a service. Now, if you do a contract worth 300 crores, 400 crores, 800 crores, and execute it over a period of 3 years, 5 years, 6 years, there are a lot of documents. You have to close all this, and this is not possible within 1 year. Had this been possible, the company would have done it long back, wouldn't have come into CIRP. So all these contract closures, reconciliation, material reconciliation, then you do a delay analysis for LDs and all that. So these take time, one in terms of documents involved, second in terms of the process, and third in terms of decisioning as far as the government authorities are concerned. So these are assets which are something which can be sold through an NRRA process where you ascribe a value to this, or you can also do a sharing. Like in some of the cases for receivables, we ask for offers. Either it can be a lump sum upfront offer against an X amount of receivable, I may get an X amount of money, and I would assign the entire receivable in consideration of that money. Or it may also happen that some of the offers may come through deferred consideration on success fee basis. Whatever is the money received, maybe it can be shared 50-50, 60-40, 70-30, whatever is the ratio which is agreed by the liquidator in consultation with the SEC. So that is something which can be considered as a fair consideration for a transparent process, as long as you are discussing this with the stakeholders consultation committee, as long as you are doing an auction, inviting bids, or doing an auction. So that's something which would help you get rid of your NRRs, because some of these sticky assets, the case which I was also telling about, the property that I have, it's an immovable property, but it's actually an NRRA for me because the sale consideration itself is under challenge. So we've got the valuation done considering this litigation and what would a third party be willing to buy, an original buyer would be willing to buy. And at that value, we are trying to sell it off as an NRRA. So NRRA would mean any asset which you are unable to sell through the available options. So that is something which can be assigned. Not much of success has been seen as far as recoveries are concerned, but I think in the market, a lot of assignments have started taking place. The next is treatment of avoidance transaction, which is also an NRRA. You can assign this to someone. Generally, if you assign this to a third party, what happens is there is no control. Vis-a-vis assigning this to the creditors. So sometimes the creditors will have a better control than a third party. So they proceed under an avoidance application where you file for fraudulent transaction. The lenders would be more interested in going after those recoveries than assigning this to a third party. So if you should discuss this with the lenders, give them both options. One, you can assign this to a third party, or I can assign this to the secured creditor. Many times, even the NRRA auction would fail. If it fails, you have no choice but to give it to the secured financial creditors. What would happen if the secured financial creditors say, we don't want to do this, you should continue? There is no way that you can continue as a liquidator. In one of my case, this was the contingent saying that the dissolution proceedings have not stopped yet, so you should continue. So I said, I am continuing till the time a dissolution order comes. So they said, we will decide only once the dissolution order comes. But that's not the intention of Regulation 44E. So in that case, you end up into a stalemate. So what can you do? I mean, as a matter of principle, you have discussed this with the SEC committee, you put this up for voting, you did not get 66%. Now you're not bound by the advice of the SEC. So what you can also do is, you can mention this in your application and you can suo motu assign this to the secured creditors of the corporate debtor, because they would be entitled, and let NCLT pass an order. You can state all the facts in that I called for an SEC meeting, put this up as an agenda, discuss this in detail, and these were the notings of the minutes of the meeting, and accordingly, they have not voted in favor of this. But as a liquidator, I can't sit here because I have to close this process in the next 12 months. And I have sold all the assets. This is not a readily realizable asset. There is a treatment to be given under 44A, which has not been agreed by the SEC. So let the adjudicating authority take a call on this. So this is what you can do. Of course, in my particular case, we have not reached that level, because what happened in this particular case was, this was a fraud company, and the company was declared as a fraud. Pardon my word. The company was declared as a fraud, and there were no details on the assets. So whatever balance sheet was available, which was 2011, 2012, basis that we had conducted the CRP process. We had got a resolution plan even in the CRP process, but the bidder walked out at the NCLT, and at that point of time, NCLT did allow it. The big judgment had not come in at that point of time. So they walked out, they forfeited their EMD amount. So basis that the company went into liquidation, we had details of an X amount of assets which were disclosed fairly to the COC members and to the stakeholders. And then we sold those companies and we filed an application for closure. All these assets were sold within 7-8 months. So we filed an application within the due date. Now, afterwards, the SFIO informed us after filing the resolution application that the company has a stake in a company, it has an X amount of stake. So basis that, we again called for a stakeholders consultation committee, we appointed valuers. So the stakeholders asked that why did this asset not come in your notice? So obviously, more than me, it is the lenders who have lent their money. It was not there in their records. It was not there in the records of the company also. Very surprising, it was not recorded by the company. It didn't come out of the forensic audit done by the lenders in 2011, 2012. It didn't come out in our transaction audit, which we did for the last 10 years. So it's been missed. So with all those documentation, we again started this. So I have to still sell that asset, and only then we would look at this Regulation 44A. As far as Regulation 38 is concerned, you can distribute an unsold asset with the permission of the adjudicating authority, and you can distribute it amongst the stakeholders. For an asset which cannot be sold, assigned, or transferred due to its peculiar nature or other circumstances. So on a couple of occasions, I had approached the NCLT and taken orders under Regulation 38. In one of the matters, this was a cooperative bank, and as a cooperative bank, when you lend to someone, you only lend to your members. So as many participants would be aware, in many balance sheets, you will see shares of these cooperative banks. So unless you have shares, you become a member, they will not be in a position to lend you money. And what I've been told by them also was, unless you are a member, you cannot initiate recovery proceedings. So I was the liquidator. I wanted to sell these shares. So they said, if you sell these shares, we would not be in a position to recover from the personal assets of the guarantor. And they sent me the regulations of the Cooperative Societies Act, which were applicable to them. So basis that, we approached the NCLT, and NCLT gave an order saying that, yes, you can assign this to the particular secured creditor, which was accepted by the secured creditor, basis that they have taken their own course after completing recoveries. In another case, before this regulation of NRRA, etc., which came in. Yes, sir, you had a question?
Yes, sir. In one of the case, like the company is under liquidation, in the process of liquidation, and there is only a sole operational creditor in the SEC meeting.
Mhm.
So, like, I have advertised for EOI, but there was no, like, interest, I mean, from any party received. Now that situation is under very, I mean, very dramatic stage. Like, who should I assign this NRRA to?
You can assign it to the stakeholder if there are no financial secured
So there
creditors.
was only one stakeholder, I mean, the SEC meeting, and that too is in CIRP.
You are in CIRP or liquidation?
That company is in CIRP. But
So
that means, what I mean to say is that the sole operational creditor who was the part of the SEC meeting, I mean, SEC itself in CIRP.
So he will be represented by an RP, right?
Yes.
You have a very peculiar situation, sir, at your hand. So one is you can try realizing the NRRA, right? And if you can't realize the NRRA to the best of your efforts, you might approach the NCLT saying that this is a not readily realizable asset. The value is nil. And accordingly,
So do you suggest, like, I filed in dissolution application that I tried my level best to sell the asset as a going concern, but nothing came forward. So, like, the honorable NCLT kindly condone this or forgo this.
So the question is, what is an NRRA? An NRRA can also be a movable asset. It can also be an immovable asset. It can also be a receivable. So if it is a receivable, you can just write it off.
Yeah, it is receivable only, sir.
So receivable, you can write it off. See, as a receivable is concerned, how do I approach a receivable? I look at the receivable in terms of the aging. If it is a receivable more than 3 years, today I have no legal right to initiate a suit. If I have no legal right to initiate a suit because I am barred by limitation, the value is zero. I would ideally say that the value is zero. It's not even an NRRA for me. And I would file liquidation closure because there is no value to this. But if it is an immovable property, then you have a problem at hand.
Okay. So you mean to say, sir, so far as immovable property by way of, movable property by way of financial assets, there won't be any problem?
If it is a financial asset, either you have to say realizable, not realizable. If it is realizable, then there is a value. If it is realizable, you will take steps for recovery. Even after recovery, you may follow up, call, meet, but finally you will take a legal recourse, right? In a legal recourse, if limitation is already over, you can't take a legal recourse. So the value of that asset is then zero because you've taken all efforts. So you have to document the efforts that you've taken to realize or recover. And thereafter, you can say, okay, I have written it off in the books of accounts. And accordingly, you can file a dissolution application. It's not an NRRA, at least from the facts that what I can gather from you.
Okay. And so, sir, like, because see, if I initiate legal action, like, for recovery proceedings and all, it will, have to incur heavy cost on that. And the corporate debtor doesn't have enough sufficient fund.
So the question is that who is the counterparty? If the counterparty you are saying is already, if the counterparty is a healthy company, you can't leave that money. You will have to initiate recovery proceeding. You will have to take that money from the creditor. Even if it is one creditor, you will have to say, and if he is not willing to give, then you file for, you say in that meeting that if you're not willing to spend any money, then the value is zero.
Okay.
Document it, move ahead. You can only do action in good faith.
Right, sir, right. Fair enough.
Take a horse to the water, can't force it to drink water.
Exactly, sir.
Right.
So I got my answer.
Sir, can I?
Yes, sir.
Sir, you said that you, in case of receivables, if it is more than 3 years, you're going to write it off in the, since it is not receivable. Assuming that if that same receivables has been shown as a asset, liability in the balance sheet of that company, so it amounts to acknowledgement of debt, sir.
That's what I'm saying, sir. If it is within limitation.
No, I'm talking beyond the limitation. Suppose if it is 4 years or 5 years, but still they're showing in their balance sheet.
Balance sheet of the other company.
Yes, sir.
As a payable. So obviously it is within limitation, but do you have anything on record? If you
No,
have
no,
the balance
no, as long as they have acknowledged it in their balance sheet,
what is the question, sir?
then it amounts to acknowledgement of debt, sir.
So it's your call whether you want to file a legal proceeding or not.
Okay,
Yeah, it's a call that you take, sir.
okay.
Yeah.
Thank you, sir. Thank you.
So next we come to waterfall on any other questions from any of the participants? I don't see any questions. No. So waterfall on distribution of the assets. So waterfall, as I've been repeatedly saying, for every insolvency professional, this is very important. Either you're doing a CIRP or you're doing a liquidation or you're an advisor, you need to understand what the waterfall mechanism is and what is the priority for assets. So from the liquidation asset, the first thing that you're going to pay out is the insolvency resolution process cost and the liquidation cost. Thereafter, you're going to pay the workman dues up to 24 months and debt owed to secure creditors who have relinquished security. So the question is, can you settle CIRP costs? If someone is willing to settle the CIRP cost, well and good, but you can't arm twist. So if the CIRP cost will have to be paid in full, every creditor knows that he has to be paid in full, if it is a CIRP cost, no one settles. So if someone is willing to settle, the answer is yes, please go ahead and settle. Because commercially, if someone is willing to take less than what you're willing to pay more, you can do that. So insolvency resolution process cost and liquidation cost will have to be paid in full. Once this is paid, then you come to second leg, which is the workman dues up to 24 months and the debt owed to secured creditors who have relinquished their security. So those who have relinquished will fall here. So workman dues up to 24 months and debt. So this is 24 months preceding the liquidation commencement date and debt owed to secured creditors who have relinquished security. Now the question which we will have different views because there are different orders and judgments. So how do you rank secure creditors in the order of their priority? Over an asset, someone has a first charge, someone has a second charge, someone has a subservient charge. Now there are two schools of thought, and prior to the Technology Development Board's judgment, a lot of people were saying that there is a pool of assets concept. Someone was saying that you will have to honor the security interest. If there is a first charge holder, he will be paid full. Thereafter, the second charge holder will be paid if there are any proceeds left after paying the first charge holder. And that's something which we were also following for a lot of our liquidation assignments. And that was what was also applicable and understandable to the secured creditors who were there. But once this Technology Development Board judgment which came, which was an NCLAT judgment, which is now pending the Honorable Supreme Court, they said no, it's a pool of funds. So irrespective of the charge, whether it's the first charge, second charge, third charge, you will have to pay everyone proportionately. So a lot of discussion, deliberation used to happen prior to that on the pool of assets or security interest. As a practical experience, what we have done in our cases and what even secured creditors as bankers have agreed is respecting the security interest. There was also an insolvency law committee of March 2018, which also pointed in that direction. Of course, the NCLAT judgment does cover everything, but it says in their opinion, it's a pool of assets, which has now been stayed by the Honorable Supreme Court. We are waiting for that judgment. However, there are some other judgments which relates to CIRP, some NCLT judgments, which some lenders would want to point you out. Now, there is no clarity as far as this is concerned. So if you ask me for my personal opinion, that's the personal opinion and what I follow in my case even today. We respect the security position until and unless the judgment of the Technology Development Board, which is there at Supreme Court, would come. I'm not aware about any other judgment of the Supreme Court, but there is a judgment of Amit Metallic in the case of CIRP. So it also points to something similar, but that's not a direct judgment. So that's what we do as far as we are concerned in our assignments. Thereafter comes the employee dues up to 24 months. So what is at the second stage is secured creditors who relinquish security. Thereafter, employee dues up to 12 months. Financial debt owed to unsecured creditors. So even if the promoter stands here, the directors are here, workmen, employees, financial debts, you will have to pay. So even if the director had a debt, which although is a related party, Section 53 does not discriminate between a related or an unrelated party. Their debts will have to be paid. In generally, in most of the cases, we stop here. But if you're fortunate to come here and here, so this is what is the position as we understand. There is no discrimination between a related party or an unrelated party. Government dues up to 24 months and unpaid debts of secured creditors following enforcement of security. So if there is a creditor who's secured having 100 rupees of debt and has realized security worth 60, for the balance 40 he is going to come here, he will not come at stage 2. Any remaining debts and dues, this would mean all operational creditors, all workmen dues more than 24 months, employee dues more than 12 months, and government dues beyond 24 months. Thereafter, preference shareholders, equity shareholders. Whatever money you collect, you distribute within 3 months. So you don't wait for all the assets to be sold and then only start the distribution. As and when the assets are sold, you start the distribution to the in accordance with section 53. It also says contractual arrangement between recipients with equal ranking shall be disregarded if disrupting the order of priority. I have not seen any practical case, but what I understand is creditors were at the same level. For example, this workmen dues and secured creditors. So if there is a contractual agreement between the workmen and the secured creditor saying that even under insolvency, we will pay the workman 100%, the liquidator may disregard if it affects the priority, because I am strictly to go by the law, because section 238 will override everything. Not contractual agreements to our understanding, but this is what it says: contractual arrangement between recipients with equal ranking shall be disregarded if disrupting the order of priority. I have not seen a practical case till now, but that's my understanding as far as this is concerned, because all contractual agreements will have to be honored. But if it disrupts the order of priority, then yes, we will, as a liquidator, disregard it. Secured creditors option, as far as his options under a liquidation proceedings, I had already covered this in my earlier slide, that he will have to identify his security interest along with the debt when he files the claim. That is something which the liquidator will verify and thereafter give it to the secured creditor. The secured creditor may deal with such assets in a matter that he deems fit in accordance with the applicable law to the assets. So generally, if it is a bank, it would sell under SFPC. They may also sell under a private sale or a private auction if their policies do allow. Dissolution of the corporate debtor. So once acceptance of claims, formation of liquidation estate, sale of the asset, realization of funds, there comes distribution under 53 and dissolution of the corporate debtor. So as a liquidator, you will make an application to the NCLT for dissolution if all the assets of the CD are completely sold and the company stands liquidated. You can file an application for dissolution. You can also file an application for early dissolution if the realizable properties are insufficient to cover liquidation cost and the affairs do not require any further investigation. For example, if you have a trading entity, as one of the participants mentioned, there are only receivables and none of these receivables are realized. What are you going to do continuing the process? Because if you're not going to get any money, the creditors will have to pay the money to cover the liquidation cost. So you may file for early dissolution.
So, sir, can I propose, suppose if that is the scene that the corporate debtor doesn't have sufficient fund to, I mean, even to meet the CIP expenses and liquidation cost, in the first or second COC, can we propose for liquidation and early dissolution?
So if you are an RP or an IRP, it is not your job to propose a liquidation or a dissolution. It is the COC
No, sir,
who
with
will
the
decide.
COC, I'm sorry, that COC will propose, like naturally COC will take a call and then RP has to move an application for liquidation.
That is allowed. That is allowed, sir. I had covered that in my first slide. At any point of time during the CIRP, the COC, even before preparation of an information memorandum, they can go for liquidation. Regulation 40A has also been inserted now, which says that the COC, while taking the decision to liquidate prior to 270 days or 180 days, will have to give reasons like technological obsolescence, closure
Sir,
of the
when this like early dissolution fits into
Early dissolution is only once the liquidation process starts. It is,
Okay,
we're talking
okay,
about two different things. So early
okay.
dissolution is, as a liquidator, if you know that the realizable properties are insufficient to cover the cost. Sir, you may please put yourself on mute. Thank you. So you can go in for an early dissolution after the liquidation process starts. If the realizable properties are insufficient to cover the liquidation cost, you can do that. And very important, the affairs do not require any further investigation. As an RP or a liquidator, you say that I don't need to investigate any further. There is no wrongdoing in the company. It's a pure commercial business law. The realizable properties are insufficient to cover liquidation costs. We can go in for an early dissolution. I have seen one instance also where they have filed for direct dissolution because during the CRP itself there were no assets. And since there were no assets, rather than getting into a liquidation and then a liquidation process, you can file directly for dissolution, but it will be very difficult for you to convince the adjudicating authority. If you're able to convince, you can do that. Liquidator shall file final report. So once the final report is, the assets are liquidated, you shall file a final report, which will give an account of the entire liquidation, how it has been conducted, how the assets have been sold. If at all the liquidation cost, which you estimated previously in the preliminary report, exceeds the estimates, you'll have to give reasons on why it happened. It happened because your estimates were wrong. You have probably had insufficient information. You thought you will be able to sell in 1 year, but it has taken 3 years. There were some costs which you were loaded with on account of rainbow paper, the provident fund judgments, so on and so forth. I did not cover this in the provident fund, the pension fund, and the gratuity issues in a liquidation. So earlier there was a judgment which says that the PF, pension funds, and gratuity will have to be paid. They sit on the top. So there was a judgment which said that all these judgments, there was the judgment of, I think Moser-Bear implied judgment was there, which said that even if you don't have funds, you will have to make provision for the provident fund dues, pension fund dues, and gratuity fund dues. So that is something which was again deliberated in the Supreme Court in the judgment of ABG Shipyard, where the Supreme Court said that in case there are no funds, the liquidator cannot be compelled to part away funds from the liquidation estate. So after this judgment, what we are doing is, prior to this, all PF dues, gratuity dues were being paid in full. Even before you paid insolvency resolution process cost or liquidation cost, but after this judgment, we have stopped paying any PF dues, gratuity fund, or pension fund. Of course, it's unfortunate on account of the workers and the employees, but that's how the jurisprudence is right now. Unlike in a CIRP, if the company gets resolved, all the PF dues, pension dues, gratuity dues will have to be paid, whether it is pre-CRP, CRP or not. That is the basis of the entire in the JET judgment. There's a very clear JET judgment which says that all this will have to be paid. Now we come also to the Rainbow judgment. The Rainbow judgment also talks about some statutory dues being secured. So that also depends upon the legislation on which it talks. So the Rainbow judgment in particularly legislated on the GVAT, the Gujarat VAT. So accordingly, wherever the respective legislations would give priority, those priorities will have to be accorded. So accordingly, all those creditors will become secured creditors now, and they will be paid along with the other secured creditors in pari passu. So that's the treatment as far as the JET judgment is concerned and the Rainbow judgment is concerned. But when you come to a liquidation scenario, your provident fund dues, pension fund dues, gratuity fund dues, to the extent there is no fund, a separate fund cannot be taken away from the liquidation estate for payment of these dues unless there is a change in legislation or the judgment is reviewed. This is what is the current position as we understand. So once you've done all this, you will have to file for a dissolution or a closure. And once the dissolution order is received, that has to be sent to the authority, which is the ROC, where the CD is registered. The liquidation has to be completed within 1 year. If you don't complete this within 1 year, you will have to file an application seeking for an extension of the liquidation period after giving adequate reasons. So this has to be filed prior to completion of 1 year so that the NCLT may hear the application and give you more time for completion of the liquidation process. So with this, we come to an end as far as the liquidation is concerned. We will go to the next topic, which is voluntary liquidation. This is fairly simple. So I will just briefly touch upon this. I am sure many of them would have done cases under voluntary liquidation also. So essentially, this is for solvent companies who have not defaulted on any debt to any person. So corporate debtor himself may choose to be wound up voluntarily under several circumstances. One would be that the articles would say that the company is only formed for a fixed duration. So if it is if the expiry of the period of operation has happened, then obviously the company can go in for voluntary liquidation. Or if the business for which the company was done, or if the company promoters are not keen to continue the business, they can go for dissolution. Generally, what we've seen is overseas companies who have companies in India, they have served their purpose. So most of these companies we've seen in voluntary liquidation. Even Indian corporates are resorting to voluntary liquidation for closure. Fairly, we understand the processes are very simple, although I have not done directly any voluntary liquidation case, but then the processes are very simple because these are solvent companies. If there are any issues that arise out of this process, for example, if you come to know that the company is unable to pay the entire debts because of some income tax claim or GST or a VAT assessment due, then you'll have to file for liquidation of the company of this company, or you can cancel the process also. So essentially, to initiate the process, the directors of the company will have to give a declaration of solvency, which will be accompanied by the past financials of the company, and also a declaration that the company is not being liquidated to defraud any other person. They will also have to give a report on the valuation of the assets of the company, which is prepared by a registered valuer. So this is something which will protect the directors in case of any misstatements with this. So once this declaration is given by the board, they will have to pass a special resolution of the members in a general meeting in favor of the voluntary liquidation, and an appointment of an insolvency professional who would act as the liquidator. In case there are any creditors, after the general meeting, the creditors meeting will also be conducted, and 2/3 in value of the creditors will have to agree to the voluntary liquidation, and thereafter the company will start the process of voluntary liquidation. Of course, the date on which the liquidation commencement date is the date on which the members of the company resolved to liquidate the company by voluntary liquidation. Once all these resolutions are passed, the process can be initiated. The corporate debtor can notify the ROC and the IBBI of the approval of such a resolution within 7 days of such resolution, and the liquidation proceedings would generally deemed to have commenced from the date in which the members have passed the resolution, subject to approval of creditors, if any. Again, here you will have to prepare the preliminary report with very similar information. This has to be done within 45 days of the liquidation commencement date. Even the verification of claims is within 30 days from the last date of receipt of claims, and the stakeholders will have to be constituted within 45 days, the list of stakeholders. A bank account will have to be opened stating in that the company is in liquidation, and all the proceeds of the liquidation estate will come in this particular bank account. You will have to recover all the money. Generally, this is a solvent company, so even the directors are going to tell you what is recoverable, what is not recoverable. And accordingly, all the monies that will come will be applied as per Section 53. In the case of voluntary liquidation, it is envisaged that the money will also flow back to the shareholders. This might be in their hands. There would be capital gains, or there would be deemed dividend also in the hands of the shareholders. Where the liquidator is of the opinion that the liquidation is done to defraud a person, he will make an application to the AF. If he suspects something amiss, he can also investigate into the affairs of the company, and he can make an application to the adjudicating authority to suspend the process and take any orders as he deems fit. In the due process of voluntary liquidation, if the liquidator is of the opinion that the company is unable to pay its debt, then in that case, he will make an application for suspension of the process and any other orders that he may deem fit. As far as the books and records to be maintained, it again says 8 years. that we will have to maintain the books and records. And once the affairs of the corporate person have been completely wound up, assets have been liquidated, he shall file a final report to the A along with an application for dissolution. Once the dissolution order is passed, within 14 days, you will have to intimate the ROC that an order for dissolution has been passed. So issues and challenges, this is something which I have left open for discussion. I've taken a lot of questions also. As far as this meeting is concerned, I am towards the end of my presentation. So some questions on voluntary liquidation, which in the initial portion, some participants had asked me, I'd asked them to wait so that I can answer it at a later time. So I'll take those questions. They're there in the chat box. So there is a question saying, in case of voluntary liquidation, if the company has only financial assets, that is investment in mutual funds, stock market, etc., the liquidator will sell the financial asset at the quoted prices in the stock exchange and realize the asset. The question is regarding distribution of the proceeds of realization. The shareholders are NRI or foreign investors. The liquidator is supposed to comply with FERA regulations before money is distributed, or it is a better way to distribute the proceeds in India and respective stakeholders shall comply with FERA. So, sir, this actually is a technical question. As I understand that when you distribute the proceeds, you will have to distribute it to the shareholders. You cannot distribute if he is an NRI, if he is based out of India. So you will have to do those FEMA or FERA regulation compliances. So it would be advisable to take advice. More than you, it is the company themselves would be aware about the process. It's a voluntary liquidation, so there will be 100% cooperation. They themselves would be aware about the process through which the money can be taken out, because the shareholders would want their money. So if the money can be given in India in accordance with the applicable regulations, yes, you can remit the money to their account in India. Or if it has to be given in their NRE account only, then you'll have to give it to the NRE account. So that will depend on the facts and circumstances. But I think you can take professional advice, and the company themselves would also be in a position to tell you.
Yeah, because sir, when the money has to be closure will happen when the proceeds are distributed, and the address of the shareholder in the record of the company is outside India. So liquidator typically has to release the proceeds outside India. Then only the closure will happen.
Yeah, and generally, even if you speak to the shareholder, because he, in anticipation of the money, would have looked at all the compliances, he will be the best person to tell you how to do this. But at the same time, it is always better to appoint suitable consultants who are going to guide you, because the other aspect of deemed dividend, etc., would also be there in their hands. So you'll have to deduct TDS also. So even there are tax deduction at source which might have to taken cognizance of.
Okay, thank you.
As far as closure, there is another question of timeline for completion of voluntary. So 360 days is not applicable for voluntary liquidation. Voluntary liquidation, I believe, is 270 days or 120 days, something of that sort. If there are no creditors, you'll have to close that within 90 days. And if there are creditors, I think it is 270 days. In case you need an extension, you need not go to the NCLT. I mean, some of the participants may correct me. You can go to the general body itself, a general meeting, and at the end of every year, you'll have to give a report to the general body in terms of the progress of the liquidation is concerned, and an extension can be granted there.
Sir, I have two questions, please.
Yes, sir.
Sir, one question is relating to liquidation. Am I audible, sir?
You are audible, sir. Go ahead.
Sir, in the case of liquidations, we have received some demand notice from the VAT department, sir.
Yes, sir.
And notice received after 30 days from the date for commencement of the liquidation, sir. Then we have requested them to send a proper application through Honorable NCLT with necessary direction, so that we can consider their claim.
So you can basically see, I mean, as a practice, what I do is I accept claims till the time I have assets to be sold and money to be distributed. I understand the regulation talks about 30 days, but if people submit it late, say 45 days, I mean, ideally you should accept that in good faith. These are good faith actions. No one is being prejudiced by accepting those claims because those are validly paid claims. However, there is also an NCLT order of the Calcutta Bench, I think in the case of Nico Corporation, which says that you can accept claims till the time the assets are there to be sold. So if someone comes and files a claim after say 270 days or 540 days, when all the assets have been sold and you filed a dissolution application, of course, yes, you can reject that. But till the time you have assets to be sold, it should be admitted in my view. I have been admitting it. Sir.
Okay. It can be admitted without the permission of the Honorable NCLT adjudicating authority, sir?
There is a jurisprudence available, sir. I think you can refer to Nico Corporation. This is a NCLT Calcutta judgment.
Okay, sir. Okay.
So if there is jurisprudence available, you can take that and treat it as good faith actions.
Okay, sir. Okay. Thank you, sir. Second question is, sir, relating to liquidation assets, sir. In the similar liquidation case, there is sole financial creditor having 100% voting right in the stakeholder consultation committee, sir. They, directors and the financial creditor have given possession and control and custody of some land. There are 2 plots having different locations, and that is a part of the liquidation estate, sir. But later on, the financial creditors have taken another stand. They are saying that the 2 plots of land, the control of which have been given to the liquidator, are not the same which were mortgaged to the bank. Because now they are taking stand that the plot which they have mortgaged is a share of big land which is owned by several persons, and there is no division among themselves. Can the liquidator change the estate, replace the estate without the permission of the Honorable Adjudicating Authority, sir?
So what I understand, sir, so first of all, liquidation estate will comprise of only those assets which are owned by the corporate debtor.
Yes.
And if assets are owned by the corporate debtor, you will have the title documents. If you have the title documents, your job is to go and verify whether this is the same parcel which has been handed over to me. If you have taken possession of a different plot of land, you would be answerable for that. You can't sell that, right? So if it is a land, you will have to go and identify the land. Are there any markings, boundaries, etc., etc.? If you are unable to identify whether this is the same land parcel which the corporate debtor has identified, if you have doubts, you can appoint consultants to verify that. So first question to answer is, your liquidation estate will comprise only of assets, and it is your job to verify whether it is the same asset.
Okay, sir.
That is the first thing. So I don't think there is any question of changing the liquidation estate. The second question, what I understood and gathered is, now the secured financial creditor is saying that the assets which have been handed over to you are not the assets which are mortgaged to us.
Yes.
So the assets which are handed over to you, if they are owned by the company, it is your asset as a part of the liquidation estate. If some other assets have been mortgaged to them, which are again owned by the company, those assets will also form part of liquidation estate. A third party asset is not going to form part of the liquidation estate. As far as your specific question for a plot of land, it's an undivided land, and you have a share of say 20%. You can only sell your 20% share. Now in the market, no one is going to buy. The other participants can only buy who have the balance 80%. So this is a land with an onerous condition. I mean, you can try your best to sell the land in consultation with the SEC. You might have to sell it at a discount because there may not be too many takers for this land because it's an undivided property. Because these properties will have ROW, right of way issues, and a lot of other issues because they cannot be easily liquidated. So valuer will have to value the land in accordance with the prevailing and the existing condition of the asset and give an appropriate value. And if you are convinced, you will have to auction for your share in the land.
But the question is that, sir, the land is not properly demarcated, sir, because we are
demarcated. You will have to get that done, sir. That's your job, in my view.
Okay, sir. Thank you.
You have to do that.
Okay, thank you, sir. Thank you.
Okay, any other questions?
Yes, sir. May I?
Yes, sir.
So my question is during liquidation, wherein if we are in the process of distribution of the sale proceeds, like we have completed with the sale process and the distribution of proceeds is pending, and during that time, like at that particular time of distribution of sale proceeds, we come to aware that there are certain important documents and information uh, in the possession of erstwhile management. That includes some key officers also, not only the directors, but some key officers also. And as a liquidator, we have been requesting for those information and those documents from those erstwhile management. And their say is that they won't be able to share those information and documents because their payments, there's some legal payments which are actually due are still pending to be paid during the CIRP or liquidation process. And we are having their claims also, which are payable. So as part of a distribution process, we are actually required to pay them also. But since they are not sharing that information documents, so we are proceeding with filing a non-cooperation IA against them. And
So essentially, I mean, if I can answer your question,
Yeah.
see, the idea is that they have some information which they were duty bound to share.
correct.
Now, you have not asked for that information earlier because probably you were not aware. Maybe once the bidder has bought the assets and you have sold all the assets, is what I understand.
Correct.
And you're in the process of distribution. Now, the only process which is remaining is distribution. And you're requesting for that information and they're asking for payments. If the amounts are payable, I mean, you can give a DD to them, hand it over and take the documents, hand over the DD to take the documents. I mean, that should be quite simple in my view.
But they are saying
Amount is payable, right?
their amount is payable, and we have recorded their claims also, and we have assured them, okay, these will be paid during the distribution process. But they are saying that since they have not been paid their past dues also by the company, so now they'll not share this information. And if you want, sir, you can approach NCLT. So while we approach NCLT, can we put their payments on hold because they are actually legally payable payments? So will it be justified on our part?
It will be justified on your part because, see, I mean, as I understand, he wants the payment. Probably it's a question of trust. He says, "Pehla paisa do and then take the documents." That's what I understand, right? If that is the only case and it's a legal payment which is due to them as a part of either CIRP cost, liquidation cost, or the waterfall, you can sit across the table and try to reason them. If you are being too unreasonable, then obviously you will have to go to the NCLT. But anyone should not mistrust the legal, because see, I mean, you're an officer of the court. There is no personal interest as far as that is concerned. So it should be quite easy in my view. Sit across the table, give them a DD, and that's what. So that's what we also do in some of the cases. In one of my EPC case companies, we had a lot of vendors who were fighting out, and their CIRP amount was due. If at the moment I would have paid them CIRP, they would have fought with me for pre-CIRP and would not have allowed my material to go out. So this was an issue on the ground. So we held their CIRP payment and we said we will only be able to release the payment basis the assets which are sold. So unless I have liquidity, you will not get payment. So we assured them on email, they agreed, the material went out and we paid them in a week's time. So that was the practical recourse that we took, because as a liquidator, I can't give you funds in advance because I don't have money. I will get money only when the assets are taken out. So once the assets were taken out, we assured them on email and they agreed to that, saying that you're an officer of the court. So I think that should work. If it doesn't work, then the only recourse is, as you've rightly done, is filing an application. But that might take time.
Right, sir. Thank you so much.
Thank you. So as far as issues and challenges for deliberation, I have covered most of this as I have moved out in the presentation. This is an ongoing concern, estimates of liquidation costs, use of estimates in preparation of asset memorandum, because if you're using the same valuation, you will have to make some changes in the estimates while preparing an asset memorandum. Sale of CD as a going concern versus sale through other modes. The sale of CD as a going concern would be the easiest mode as a liquidator you could adopt, but you can do it only exclusively once. So when you do it for the second time, third time, you do option A and then multiple options so that both things go on simultaneously. Settling the priority waterfall I've already covered. Closure of pending cases is what I've already covered, and assignment, the sale of NRRAs, including proceeds from avoidance applications. So with this, I come to an end. I had a time up to 5 o'clock. We are exactly at 5. I come to an end of my session. If there are questions, I am willing to take them up now also, or you all can connect with me also, whichever way. I can't see any questions in the chat box now. Any questions, or over to the moderator?
Thank you, sir. It was very wonderful presentation. We learned a lot. Thank you so much.
Sir, one more query, sir.
Yes, Amit.
Sir, in one of my matters of liquidation, I have completed the liquidation process. I filed an application for dissolution with the court, which is still pending with the court. But it's been more than 2 years have passed filing that application of dissolution. So whenever the hearing will be coming up next, I'm quite sure within a month or two, the dissolution process will go through. But just a few, just 1 or 2 weeks back, I came aware, I came to know about somebody informed me about an asset in the name of the company, which was never recorded in the balance sheets of the company, nor with any of the financial creditors, was not mortgaged anywhere. It is an immovable asset. But I inquired, and that's an immovable asset in the name of the company, which was never being reflected, never shown anywhere. And now I have come across that piece of land. So if this dissolution goes through, that piece of land won't be able to, we won't be able to sell out.
Right. So I shared my own example, a very similar example I had with very similar facts. So you have to withdraw the dissolution application, and you will have to sell this asset, take possession, distribute the funds, and then again file for dissolution. That's what you'll have to do.
So in this process, like, we'll have to keep the dissolution application on hold, and we'll have to modify the liquidation estate also. We'll have to, with the permission of court.
No, so basically what you'll have to do is you have to file an application for withdrawal, modification of the liquidation estate. I don't think for liquidation estate you need the permission of the court. You can say that this is, the facts are this, and this is what has happened. We were not aware, no one has even told us about this. This has now come to our knowledge. I have taken possession. I'm in the process of stage. I'm withdrawing the dissolution application, and kindly extend the time for liquidation. So you'll have to ask for an extension of the liquidation time also. So that's what you'll also have to do. So the NCLT will have to allow you to withdraw, sell the asset. Of course, sell the asset is your right because it's an asset of the corporate debtor.
Okay.
And it will also have to extend the time for the liquidation process. I think that's important, the last one.
During this process, do we have to proceed against the suspended directors also? Because we have been seeking information from them, replies from them regarding whenever we came aware of this property, we sought replies from them that we have come across such information, such asset is in the name of the company. We need the documents of this property, and we need the reasons why you have not disclosed the existence of this asset in the name of the company, and they are not replying also. So do we need to proceed against those directors also?
Yes, 100% will have to proceed. So since this is a plot of land, so someone would be going there, some property tax would have been paid.
Yeah.
Someone would be utilizing this. If you have to gather all this information, if you have all this information, you will have to refer to offenses and penalties, saying that knowingly, if they have not shared any asset in this process, there is, I think, imprisonment as well as fine. So you should take that recourse rather than a non-cooperation. You should take recourse to offenses and penalties.
Perfect. Thank you. Thank you so much.
Thank you. Any other questions?
It's fine, sir.
Thank you. Thanks a lot. I will stop sharing my screen.
Thanks for such a wonderful session, sir. Thanks a lot.
Thank you. Thanks.
Thank
It's
you
been
very
my pleasure. Thanks a lot to all the participants.
Thank you.
And if there is
very much,
anything,
sir.
I mean, you all can reach out to me. I'm always available. Thank you.
Thank you so much, sir. The session was very interactive and informative. Please share the PPTs, sir.
Sure, ma'am. I'll do that. I'll exit the meeting. Thank you.